Pledge allegiance
to the flag of the United States of America and to the republic which stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening. This is the Board of Commissioners meeting for May 26, 2009. First item on the agenda is the minutes of the public meeting of May 11, 2009.
Will they be approved?
Do I have a second?
Second.
All those in favor say aye.
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 Any opposed? Next is notice of executive meetings. An executive meeting was held in the Powys Caucus Room prior to the public meeting of May 26, 2009, where personnel, real estate, and litigation matters were discussed. All commissioners were present except Commissioner Paolino. Next is the proclamation regarding National Safety Month. Commissioner Mahoney.
Yes, I'm going to go down to the podium to do this.
What? Yeah.
Thank you. Is this on? I'd like to ask the co-chair of the Township's Workplace Safety Committee to join me up at the podium, Ricky Foster. He is the co-chair, together with Amanda Ostrander-Sirac of the Township's Workplace Safety Committee. This is a proclamation because June is National Safety Month, and I'd like to read the proclamation to you. Whereas this June marks the 13th anniversary of National Safety Month. This annual observance reflects the National Safety Council's historical commitment to inspiring people to adopt and maintain safe and healthy behaviors in all aspects of their lives. And whereas the National Safety Council established National Safety Month in 1996 to increase public awareness of safety and health risks and to ultimately decrease the number of accidental injuries and deaths in the United States. And whereas the National Safety Council is aggressively urging businesses of all sizes to set standards for safety within their organizations that include the safety and well-being of their employees' families, as well as the communities in which their businesses operate. And whereas Radnor Township's Workplace Safety Committee is the steward for promoting and communicating these safety standards to Township employees, and whereas this year's National Safety Month is focusing its efforts in 4 key areas: teen driving, falls prevention, overexertion, and distracted driving, in order to increase safety awareness and education in our homes and communities and on our roads and highways. Now therefore be it resolved that the Board of Commissioners of Radnor Township does hereby thank and honor the Workplace Safety Committee for its achievements in increasing awareness of safe and healthy practices and their efforts to instill a culture of safety throughout the organization, and encourages all businesses in the Township to do the same. And I will move this proclamation.
Second.
All those in favor?
Aye.
Ricky? Just say a few words, sis.
Yes, please. First of all, I'd like to say thank you and good evening to the Board of Commissioners. In accordance with the National Safety Council's National Safety Month, the Township's Workplace Safety Committee has been working hard to increase awareness of the importance of safety in the workplace. Our committee, which consists of 16 employees representing each department of the Township, works hard to ensure that the employees stay safe on and off the job. Some of this month's highlights include Lunch and Learns, where employees bring their lunches and receive in-house training on various safety topics. Certified training for staff workplace safety committee from our insurance carrier. Video training for our public works crew, and a special edition of our safety update newsletter, which is located in the back of the room for the public to view. Also, please note that this year, the Township's Workplace Safety Committee has a dedicated section on the website under Township Administration at www.radnor.com that is updated regularly with safety newsletters and various safety documents that are filled with valuable information, all of which are valuable and available through our website for the public to download. In addition, we think it is important to note that by having a certified workplace safety committee, our township receives 5% savings in our workers' comp premiums, which since the committee's inception in 1995 has saved the township several $100,000. In closing, myself and Amanda Ostrander-Sirac, co-chairs of the Safety Committee, would just like to not only thank our committee members for their hard work and commitment, but also you, the Board of Commissioners and Township staff, for your continued support.
Thank you.
Thank you. Appreciate it.
And Amanda, thank you for all the work you do for that committee as well.
I'm going to go back to the agenda, and I'm going to skip a few things so that we can come back to this hearing on the signs. Departmental reports.
Will they be accepted?
Second.
All those in favor?
Aye.
Under community development, we have certificate of appropriateness for Thomas B. Hannum to conduct a wraparound porch at 316 Orchard Way.
Move the approval?
Second.
Anybody here to speak on this? Seeing no one. All those in favor?
Aye.
Aye. Any opposed? Next is certificate of appropriateness regarding James Warren to construct a rear family room addition at 202 Poplar Avenue.
Move the approval?
Second.
Anybody here on that? Seeing no one? Okay.
Yes. These are HARB decisions.
These are the HARB's decisions.
That they already approved them.
Yeah, we're basically being asked to approve their recommendation. All those in favor?
Aye.
Aye. Any opposed? Next is the reminder of the 2009 Mainline Jazz and Food Festival on June 13, 2009. Was anybody on staff going to talk about that, or is that the reminder?
I can do it. The Wayne Business Association has their Mainline Jazz and Food Festival Saturday, June 13th. Center of Wayne will be transformed into a European-style piazza where music lovers can dine al fresco at bistro tables, enjoy great music as a lounge under the stars. Live music, great food, fun for the entire family. For more information, they can visit www.mainlinejazz.com. The event begins from 11 to 4 p.m. for a lot of the activities, and then the music is from 4 to 9 p.m.
Thank you. We'll come back to finance and audit. There's nothing under library. Under personnel administration, we have...
Excuse me, I just want to point out that the library, the president of the library board of trustees sent a letter expressing concerns regarding the open air market, which I think all of us received. Is that? Okay.
Okay, under personal administration, we have some appointments.
I'd like to move the appointment of Leslie Kramer from Vassar Circle to the library board.
Do I have a second?
Second.
All those in favor?
Aye.
Any other appointments?
I'd like to nominate Stephen Cooper for the park or the planning board.
Second?
All those in favor?
Aye.
That's it for personnel administration. Under park and rec,
Two things tonight, Tom. First is the announcement of National Trails Day on June 7th, 6:30 to 3:30. We're going to celebrate National Trails Day on the Radnor Trail Sunday, June 7th, 2009, from 6:30 a.m. I won't be there for the opening. Tom might be. To 3:30 p.m., visit our tents at the Brookside Avenue and West Wayne Avenue parking lots for morning coffee, midday snacks, and more. For further information, you can contact the friendsofradnortrail.org, sponsored by the Radnor Township Park and Rec and the Friends of Radnor Trail. Sunday, June 7th, 2009, National Trails Day on the trail.
And it also said if it rains, you can call WW Friends of Radnor Trail to see if it's been changed to another date, just in case it rained hard that day.
And the second thing is Radnor Township Park and Recreation Department would like to invite everyone to join us in a ribbon-cutting ceremony to commemorate the opening of the recreation facility, the Radnor Activity Center at Sulpizio Gym. It's actually 125 South Wayne Avenue behind the Radnor Fire Station. That's on Saturday, June 27th from 10 to 10:30, rain or shine. It's going to be a ribbon cutting, And following the ribbon cutting, the facility will be open from 10:30 to 11 for individuals who want a tour of the Radnor Activity Center at Sulpizio Gym. For any question, call Park and Rec here at 688-5600. But we're going to formally reopen the gym that's really turned into a nice centerpiece for our Park and Rec group, and something that we're all proud of and should be a great thing for generations to come. That's it for Park and Rec.
Speaking of ribbon cutting, this Saturday, May 30th at 10 o'clock is the ribbon cutting at the D'Antonio Park, which is the park right behind.
Friends of the Radnor Trail.
That's right, Friends of the Radnor Trail Park. This is the official opening and ribbon cutting. And for anybody that doesn't know where it is, it's off West Wayne Avenue behind Dr. Hunt's and Vic and Dean's. It should be a nice ceremony. If you can make it, be there. Thank you. Public health, there's nothing on the agenda. Is there anything?
I just want to give an update on the H1N1 swine flu. There are now 6,552 cases in the U.S. with 9 deaths. The CDC is still asking Americans to take extra precautions because they believe that the H1N1 will reemerge in the fall, possibly more dangerous than it is. And they want us to use universal precautions like washing our hands frequently with soap and water, cover your mouth and nose with a tissue when coughing and sneezing, avoid touching your eyes, nose, and mouth. And people who are sick with influenza-like illness should stay home and minimize contact with others, including avoiding travel for 7 days after their symptoms begin or until they have symptom-free for 24 hours, whichever is longer, and then to avoid contact with persons with influenza-like illness. If you want more information, you go to cdc.gov. Thank you.
Thank you. Public safety.
First item is the Staff Traffic Committee report. You have before you the minutes of the Staff Traffic Committee meeting for April 21st, 2009.
Move be approved.
Second.
All those in favor?
Aye. The next item is simply a reminder that we're going to be having our next public meeting, not here in this room, but at the Radnor Fire Company. The head of the fire company, Dave Roderick, was kind enough to invite us. We have precedent for holding meetings outside of the Township building, and so on June 15, 2009, we will have it at the firehouse. It'd be a great opportunity for people to come over and see the facilities, talk with some firemen, and maybe get a chance to check out some of the trucks after the meeting or beforehand. So come on out on June 15, 2009 to see our public meeting there.
Thank you.
That's it for public safety.
And is there anything under public works?
No, there's nothing on the agenda.
Okay. Why don't we go back to item 5 on the agenda, which is the public hearing regarding the off-premises signs. And I'll ask Solicitor John Rice to give us the background and explain again to the board and the public why we are doing what we're proposing to do at this point in time.
As the board knows, this whole process started in January through the adoption by this board of a municipal curative amendment resolution. And before I explain what that is, the history on off-premises signs, I'm going to call them off-premises signs because that's the obligation that I think the courts have laid down for all municipalities in the state, not billboards, off-premises signs. The Pennsylvania Supreme Court decided a case out of Berks County in January 2009, which essentially said that particular municipality, which was Exeter Township, his ordinance was unconstitutional because it permitted off-premises signs, but it didn't permit enough or large enough off-premises signs. And they found that in that case, the billboard company, and it was a billboard company, would be able to put their billboards, which are typically, the industry standards, about 672 square feet, in that township because that township's ordinance provided for it, but just not enough and not big enough. The Pennsylvania Supreme Court, and I'm not sure if folks are aware of this, is a very strong property rights court. This is a property rights state, notwithstanding, aesthetics and everything else. This court has a history going back many, many years in being very strict about property rights. And that's why we have these types of court cases. Now, that case is 2009. In 1965, the Pennsylvania Supreme Court rendered a decision which said you have to provide for off-premises signs in every municipality in this state. So the law has been around since 1965. This is before the Municipalities Planning Code, which came into effect in '69. But the law has been since 1965 that all municipalities have to provide for off-premises signs in some fashion. And what municipalities do in a given area, a given county, a given part of the state is all different. It's all over the place. But the basic rule is you have to provide for it somewhere. And that's been the law prior to the MPC in a case that occurred in 1965. With the Municipalities Planning Code, a lot of those old cases, zoning cases, got codified. And there are procedures in the MPC since '69 which tell you how to fix a problem. And one of those ways that you fix it is through the Municipal Curative Amendment Resolution, which is what this township did in January in response to the 2009 Pennsylvania Supreme Court decision. What the Municipal Curative Amendment Resolution process does, it permits a municipality to adopt a resolution, identify a problem or an issue in their ordinance, and they get 6 months to fix that. So the process in Radnor started in January of this year, and the 6 months will run from, I believe, January 5th is when the board, the commissioners adopted that resolution. So we're under a strict timeline to do something because in this township, as in some of our adjacent neighbors, there's no provisions for off-premises signs. And that's called a total exclusion. What happened in Berks County is called a partial exclusion, and they got hit on that appellate court case. So if you don't provide for an off-premises sign somewhere in your municipality, the remedy that a landowner gets is they get to put whatever they want on their land. So the municipal curative amendment process is sort of a self-help procedure. So municipalities have some control over where off-premises signs go, what size they need to be, and other types of design features. And that's what Radnor initiated in January of this year. The ordinance that was drafted, and this was done through the township's planning department, through my office, attempts to provide for the use in what we believe will be the least noxious or invasive manner that we could come up with in this township. We looked at a lot of different scenarios. We looked at locations. We looked at sizes. And given the fact that we're obligated to provide for the use somewhere, it is, I think some of the commissioners had said, you sort of got to pick your poison when you're dealing with this particular use. It's again, not something that you can ignore and say, let's just fight this, because if you lose, landowner gets to do whatever they want. That's the remedy. It's called site-specific relief. And if you lose a challenge, there's no negotiation. I've been involved in probably 20 curative amendments in the last 10 years alone, and some of those get negotiated, but if the landowner has a slam dunk under zoning law, they'll do whatever they want to do, or whatever they've asked for. And it's my understanding that in Marple and Haverford, they're looking to put up 672 square foot signs somewhere. So that's the background. That's some of the background of the law and how we're
John,
at
could I just add,
where we are tonight.
let me just add one thing. The real precipitating factor for this was information that we received from a local businessman who had been approached by the same company, the same sign company that is fighting Haverford Township presently, and that business owner said he was being solicited to offer up his property or to negotiate a lease for a sign for his property. Therefore, we knew that this particular sign company was looking at Radnor as a target community for these signs. So,
And that's typically, in this type of a use, that's typically, what happens. And so this ordinance is an attempt by the township to inoculate itself against that happening, what was just described. The ordinance was drafted, I guess, in February, March. It's been reviewed at this point by both the County Planning Commission, the Radnor Planning Commission recommended that it be adopted. It's been advertised for adoption tonight because we are under a tight time clock given the advertising procedures and the adoption procedures in the MPC and the charter in this township. The ordinance, just a couple other things. This has been advertised May 6th and May 13th in the newspaper. Just to summarize the substance of it, Mr. Loper has some maps, and I guess are they up at the table, Bob? Okay. Can we, because there might be some questions. What the ordinance does do in terms of permitting off-premises signs, first of all, the largest off-premise sign you can have in either of the two districts is 64 square feet. I know there's concern about Wayne and the business district and how this might fit in. The township zoning ordinance currently permits 50 square feet in Wayne. 50 square foot wall signs are currently permitted. So these signs are going to be marginally larger than that, but in terms of size, it's not 300 feet or 672 square feet, which is what Radnor would get if there was a landowner curative amendment. The two districts where the use would be permitted are in the Wayne Overlay District and the portion of the C3 district which fronts on the Amtrak SEPTA right-of-way line. They're the two areas. In either of those areas, there's a special exception required. So these are not uses permitted by right. These are uses that a landowner, let's assume an advertising company has an agreement with a landowner for a lease. That company then has to file a special exception application to the zoning hearing board, which then provides for resident input, township input, and any application would be subject to a list of standards that are spelled out in this ordinance. Ultimately, the zoning hearing board could grant or deny such an application. So they're the two districts. The ordinance also provides for some setback requirements, 100 feet within the Wayne Business Overlay District, and also 100 feet in the C3 district from any adjacent residential zoning district. There's also some setback requirements in the ordinance in terms of the right-of-way and the street cartway, and there's a requirement in both of the districts that no off-premises sign shall be located closer than 100 feet to any other off-premises sign. There's some other design standards that are in here. The height can be no more than 15 feet. There can only be one sign or advertisement per face. There's a lighting. We've incorporated the existing lighting requirements that are in the existing zoning ordinance. There's a prohibition against revolving electronic digital signs for these types of signs. There's also a requirement that the Design Review Board review and make a recommendation prior to any trip to the zoning hearing board for the special exception. This is, as I said, something that, in my view, is not optional. for this township, because I think the cure is much worse than that you would get with a landowner curative amendment than what the township's trying to do here. It's obvious that there's a company that is looking to install large billboards throughout Delaware County, and actually there's a couple cases in Montgomery County that I'm aware of, and it's something that the township's at risk at. No one likes this. I certainly don't like to tell you have to adopt an off-premises sign ordinance, but it's something that the Pennsylvania Supreme Court requires. That's the summary. If the board has any questions.
Well, I think at this point, unless the board feels differently, I'd like to open it up to the public, because I know there's some folks here who have come prepared to give us their thoughts about this proposed ordinance, and I'd like to invite them sooner rather than later. So,
Members of the board, I'm Cromfield Crawford Jr. I am not a resident of Radnor Township, but consider myself a friend of Radnor Township. This is Sandy Karate with me. We are both members of Wayne Presbyterian Church, which, as you know, is a bit of a centerpiece on the north side of Lancaster Pike in the Wayne Business District. Sandy is going to discuss with you some of her concerns about the locational aspects, and I would like to, first of all, agree with Mr. Rice on the basic premises that the township, of course, has been vulnerable to a exclusion issue. What the Exeter case did was to go one step further than the de jure, as, again, I'm agreeing 100% with Mr. Rice's analysis, that a de facto exclusion based upon a 25 square foot limitation for off-premises signs was effectively a de facto. That's what de facto is. You allow for it by some words in the ordinance, but you effectively exclude. So you do have to do something. We think that you do have time before the 180 days expires to do some revisions. We would like to suggest some revisions. Again, Sandy will talk about locational components, but I would like to offer a little bit of a nuance on the law and how it would apply here. I think that the definitive relief issue is a major issue for you, as again Mr. Rice points out. However, this ordinance almost, within the size limitations, grants definitive relief to every property owner in the Wayne Business District. What the courts have said, respectfully, is that an off-premises sign or a billboard is a principal use. By definition, it's not an accessory use because it relates to something that's off the premises. And therefore, it is mandated that off-premises signs be allowed as principal uses. In other words, a single permitted use on a commercial property. Here, this ordinance as drafted blurs that distinction and essentially rewards every property owner that already has a retail store or an office building or some other property being used in Wayne for a bonus. Take, for example, and that bonus is to put up a 64 square foot sign in addition to the on-premises signs. We suggest to you that the appropriate thing to do, whether it would be in Wayne or elsewhere in the township, is to differentiate between on-premises signs, which are accessory signs, and off-premises signs, which you can limit properly to being the sole principal use of a property. To give you an example, if you're traveling eastbound in Wayne, you have a fairly new building, the Prudential Real Estate Office Building. And there's a monument sign out front that presumably meets your requirements. I'm not sure how many square feet it is. That sign could be doubled. You could add an off-premises sign for some other use right there on that lawn area in front of Prudential. There's lots of other areas. By the way, I will also say that my family, and I have a small part of that family interest, has a partial ownership interest in commercial property in Wayne. And so I'm here not to espouse our financial interests, because I think that to pepper Wayne or anywhere in Radnor Township with several off-premises signs, even at the size of 64 square feet, would be a bad thing to happen for Radnor Township. And I do think that even though Mr. Rice has analyzed this properly, and I don't disagree with a word that he said about the obligation, that by properly distinguishing between off-premises signs, you can actually make this far less palatable. Sandy, yeah.
I just have one question for you. There's no off-premise place, a lot, or anywhere where you're going to have just a sign in Radnor. Isn't that exclusionary? There's no place you could put it.
No.
Land's just so expensive that you're not going to take a piece of ground and say the only thing we're going to have on it is a sign.
No, there are signs, for example, I think it's in Tredyffrin, right by Old Lancaster Road, where it comes in there. You have narrow properties.
I know, but we don't have that in Radnor.
Well,
Hold on, because I would like to understand the nomenclature here, because I'm already a little confused, frankly, with the principal use, the accessory use.
Okay.
And now you're using analogies, and Mr. Spengler may know what you're talking about, but I don't.
Okay.
And I'd like you to be as complete as you can in your explanation. You were talking about a location in Tredyffrin Township?
Yeah, it's a small sliver of private property between
Where?
the railroad line and Lancaster Pike.
Across from the Volkswagen place.
Yeah, and there's a couple of billboards there because it's too
Okay.
small for commercial use. So my feeling is that someone can, if they really want to put a billboard up, they can come in and try to subdivide a property, but you don't have to go through every single property that's eligible for the use. Again, whether it's in Wayne or somewhere else, and we think that Wayne's probably not a good place for this, partially for that reason, Bill. You may find other properties that could have the sliver of use somewhere. But you don't have an obligation to try to analyze every single property. What you have an obligation to do is not zone the Wayne Presbyterian Church and St. Catherine's and St. Mary's as the only locations. That would be de facto exclusionary, because obviously those properties aren't going to be putting up billboards. But you don't have to analyze all of the commercial properties in Wayne and say, well, this property isn't ever going to have a billboard. They might. I don't think you have that obligation.
No, but you're talking about a single use.
Right.
I can't think, and I know every property right now, in the district, I don't think of one single use where you could put a sign up where there's no other use on that property.
What about the area between the off and on ramps for 476?
That's not in the area we're proposing.
Well, I think when we go through, if you'd like to look at this plan, using...
Well, I'm just making the point is that if someone went in with the statistics with the court and showed in the districts that we have there that there's no place you can put one on a piece of property as the only use, that would be exclusionary. That's the only point I'm making.
Okay, and I don't think you have to go, how many properties are there that you have zoned to be eligible for this, or will you zone to be eligible for it? A multitude. Again, if you single out, if you go back to, for example, the Immaculata College case, Willistown zoned that area solely for its multifamily use. Well, that was one property, institutional, that was never going to be developed. You don't have that here. You don't have to go through all of the properties, the multitude of properties that you're going to zone, whether it's in Wayne or somewhere else, as eligible for billboards, and say that this property owner will never put up a billboard. They might.
Of course they might. I have a question, because I'm looking at all these dots on the area here, and obviously those are places you think that someone could put one. But unless I am mistaken, they have to subdivide those properties to do so.
Correct.
Okay? So someone has to take their property, a shop in downtown Wayne, and go to the zoning hearing board and subdivide it. And you're telling me they can subdivide the sidewalk portion off or the front portion off
Well,
Okay.
this map, just to be clear, this map was just taking the ordinance and saying, using the scale that was on the zoning map, and saying one every 100 feet or one per parcel, whichever comes first.
Let me just interrupt you for one moment. Since this is a public hearing, should we be marking these as exhibits with exhibit numbers?
I don't think it's necessary to mark them as exhibits. This is not a, this is a legislative hearing. I would like to, I don't have a copy of whatever was handed out, but it would be nice to identify at least for the,
But John, what are your thoughts? I mean, you have to subdivide your property. If you own a property in Wayne, you own a store, you have to go to zoning hearing now, what you're saying. But what I'm understanding, we have to go to zoning hearing board.
I'm not a lawyer. So
No, I
have
know,
to talk
Fron. You have to go to the zoning hearing board, subdivide your property. Now you have two parcels that you're paying taxes on. One small sliver that you're going to put a sign on, I guess you could draw income from, and then you have the other one, right?
Right.
Which I guess is possible.
Yeah, a special exception a special exception is a permitted use with conditions. So you're not blocking signs, billboards, or off-premises signs by making them special exceptions. You are allowing the zoning board to impose conditions. But you're not being de facto exclusionary by making it a special
So
exception.
you're saying, according to our ordinance, all these people could put a sign where these dots are?
Yeah.
I think without the ordinance, people can put the signs where the dots are. I think it's a complete opposite.
I think you have to pass an ordinance. I think you have an obligation to protect Radnor Township by passing an ordinance. All we're suggesting is that you have some time to reconsider some of these decisions and do what we think is a better job to protect Radnor rather than to invite billboards into the township. You don't have to invite them. You only have an obligation
We're not
to
inviting
provide
them,
for them.
but we're not inviting them. But why?
I think you are.
I think by not doing this, we're inviting them. We actually know that from Lower Merion and Haverford Township.
Well,
They
you have
haven't
to
done
do an
anything.
ordinance.
Well, let
What's
me ask
that?
you, do
You
you,
have to
do
do
you
an
have
ordinance.
language or
Yeah.
suggested language that you can circulate
Sure.
to our solicitor and to us so that we can
Yeah,
get a sense for
absolutely.
what you're recommending?
I just passed a copy to Mr. Wright.
Mr. Masterson, just one comment. I understand what this gentleman's suggesting, that you require that off-premises signs be on their separate lot. A lot of municipalities do that. Municipalities that do that are very rural. I represent a couple that have done that. But the lot size you're talking about is probably 10,000 square feet or thereabouts. And in a developed community, I'm not sure you're going to find too many places where you're going to be able to subdivide 10,000 square feet off of an existing lot, to put a billboard on it or some other type of off-premises sign. So I think that's the distinction that's being made here, because that's not required under the proposed ordinance.
Well, what I don't understand, John, is you have this in front of you,
I have this map.
this map. Well, they have a dot here with 50 or 60 signs he says they can put up under our ordinance right now.
Under the existing.
Yeah.
What the ordinance that was just written, it's
Yeah, no, I
one
understand
every
it.
100 feet, and,
I'm sorry, miss, I'm talking to the solicitor right now.
Well-
okay?
okay.
Okay.
Bill, I mean, if that's just 100, using the 100-foot separation, there's some other setbacks or some
Yeah,
height
that's what I
requirements. I mean, you'd almost have to go to each building or lot to see what
But
kind of sign. There's
are these-
existing signs on a lot of
Are
these.
these dots just 100 feet apart? Is that all
Yes.
they are? You didn't do anything else with the ordinance, setbacks or anything? These aren't
Well,
correct
it-
then?
It's in like 1/64 scale, so the dot is not even in proportion.
No, I understand the 100 feet, but there's other setbacks and other things
Well,
here.
hold on,
It's
hold on for a
only 10
second.
feet.
Hold on for 1 second, please. I'm just looking at the language that Mr. Crawford has submitted to us, and I'm just looking at it for the first time. It does not appear to me that it changes this proposed ordinance in any dramatic way. It doesn't touch any of these setback recommendations. It basically modifies what the ordinance says by adding this sole principal use condition, if I'm reading this correctly.
Mr. President, that is correct.
Is
This
there any
not a
reason not to
radical
do
change.
that?
I think the reason not to do it is something that Bill alluded to right off the bat, is that if you make this a sole use on a lot, then you've got to do a subdivision. You've got to pick a lot size. How many properties that are within these two districts now, especially in the Wayne Business District, would you be able to subdivide a lot off of?
So you're saying that is getting back to what he started out saying is like a de jure or de facto
That would be in my view,
restriction?
in my view, unless you wanted to do a parcel by parcel analysis, I would see that as a de facto exclusion, but you still would have to pick a lot size. I don't see a lot size in here. I know there's a minimum lot size currently in that district, but you would have to pick a lot size for a off-premises sign as a principal use. And then you'd have to determine on every parcel, are there enough lot sizes you could subdivide off? I mean, it's not an uncommon practice to do this, but it's always done in a rural, less developed municipality, because you have, I don't know how many vacant lots there are in Wayne.
I understand what you're saying.
Yeah,
So-
John,
so-
let me
East
just-
Whiteland
let me
isn't
just
there.
ask a question before we go from it. Maybe this is directed to Matt or, Matt's not here, to Bob. What is the minimum lot size in these districts?
In the WBOD district, it's 20,000 square feet minimum.
There's an answer.
I have a question.
I want to hear
I'm
the
sorry,
answer
go ahead.
first. Go ahead, what's the answer?
The answer is you can set another specific lot size for off-premises signs as a principal use. You can make it dependent upon the total size of the sign, for example. And I think you have some vulnerability with regard to 64 square feet, to be honest with you. The Supreme Court said 25 square feet's no good, and 300 square feet's too rigid. So we're not going to say you have to have 300 square feet, but I would rather see I'd rather see you be safe on the size, which I don't think you are at 64 square feet, and then you can set a floating minimum lot size that reflects something up to a maximum. And I don't know, I don't have the magic on where the size is. Maybe 64 square feet will fly. All we know is 25 square feet doesn't fly, and 300 square feet is too rigid. So I'd rather see you be safer on the size and more restrictive on the process by which a billboard could be permitted, whether in Wayne or some other area. You've got a long section of Lancaster Pike. East Whiteland is not rural. East Whiteland allows off-premises signs within what they call the gateway areas, which are the first, I think it's either 500 or 1,000 linear feet of Lancaster Pike as you approach the eastern and western borders of the township. So, I'm not saying that necessarily works here, but it's an idea that might take you out of downtown Wayne, where you've put a whole lot of effort as a township into creating a unique village. And so, to me, again, I don't know all of the reasoning that went into picking Wayne, but it seems to me
I have a
that-
question.
Yeah.
I just want to get as many facts in front of me as I can. On your draft, you're saying that the off-premise signs will only be permitted in as a sole principal use. And when I think of Wayne, we don't have open space, okay? So isn't that a de facto exclusion? When you're basically saying we're only going to allow them as a principal use, no one's going to tear down $1 million building in Wayne to put a sign up.
I think that's all the more reason
Okay.
to put them someplace besides Wayne.
Okay, and when I look at this drawing, I see all the red dots, and I appreciate you taking time to do that. That's very helpful. Visualizing this is helpful.
I have a sign, the 8x8 sign
But-
rolled up there if you'd like that.
Yeah,
But
but they
I want to
can't-
let me finish my comment.
There's no
The
signs
comment
on the front
is
stores in
that
Lancaster.
right now, in that same district, we allow signs that are 50 square feet, yet in that district, I don't believe we have that many 50-square-foot signs in Wayne.
No, there-
In fact, we probably have very few of that size. So just because we allow something doesn't mean that commercial property owners will choose to aesthetically destroy the value of their property by putting a big sign on it. As a landlord of commercial property, you're not necessarily going to allow your tenant to put up a large sign. The code may permit it, but the landlord won't. And quite frankly, the value that a landlord can get from a 64-square-foot sign is far less percentage basis than the rents they can receive from a storefront. Storefronts in Wayne garner $6,000, $7,000 a month. I don't think someone's going to pay $6,000 or $7,000 a month for a 64-square-foot sign in Wayne. I just don't. I don't believe it. I just economically it doesn't make sense.
Right now, they can have their cake and eat it too under this draft. They can have their storefront, they can have their use, and then they can take their building and take the size of the building. If it's a row situation like the
Wayne
former,
Sporting Goods.
Yeah, then you're not going to do that. But,
Right.
But you have a lot of corner
but,
buildings.
But I'm sorry, and I haven't looked at this draft in a couple of days, but
Wawa would
we
be
have a
the same.
limitation on height, okay?
15
And-
feet's good.
But the point is that with a 15-foot height limitation, I don't believe you can put a sign in Wayne. I mean, you're not going to see that many of them. There will be signs, they will occur, but not in quantity. I mean, I don't see a property owner who owns a very expensive commercial property in Wayne defacing it by allowing their tenant, or themselves even for that matter, to put a sign up on the face. It doesn't, it's going to happen, we have to allow it, and I think this is a very honest attempt at allowing the rights of property owners as required under law, but not necessarily, opening the door to what's happening in neighboring townships.
You will open the door. There may be, as you say, sufficient sentiment among the property owners in Wayne. However, understand that once the dam is breached, then you're going to have a whole lot more willing to breach it. And you have set Wayne up to be a special overlay district. You have design review requirements. You have always tried to protect the aesthetics of Wayne. I strongly suggest to you that you're opening the door, and as soon as you have one or two that are willing to take an additional couple thousand maybe a month, I don't know what it goes, but let's say it's $1,000 a month, over and above the rent that they're getting for their existing storefront, all you need is 2 or 3 or 4 breaches, and the other property owners are going to say, well, if they're doing it, why don't I do it?
Can we go back to my original question about if I own a storefront in Wayne, I have to subdivide my property to do that with this ordinance.
Not under the pending ordinance.
No, his subdivision is his.
suggestion.
You got to have a separate lot.
Right.
His suggestion, not under our ordinance.
Right. So you have to subdivide the property. You have to go to the zoning hearing board and ask them to subdivide your property, make it 2
Go to
parcels.
commissioners.
Okay. But is it commissioners or zoning board?
Commissioners.
And the commissioners have to approve that.
Yeah, but
Okay. If the commissioners deny it, you can appeal it, go to a judge. And the judge is going to say, I'm going to take my little storefront in Wayne because I want to make $1,000 a month by putting a billboard on the front. I'm going to subdivide my property. I mean, does that make sense to me? I don't know.
Let me suggest.
Does that happen, Frone? Do people do that in your experience?
Usually they use existing remnant parcels. That's the more common approach.
Right.
But what I'm suggesting to you, and what Sandy is suggesting to you, is that rather than invite a bonus use, this is a bonus use to any property owner who wants to do it. You have, I think the lot size issue is a major issue. We didn't deal with that. I think you have to deal with that issue because you can't require 20,000 square feet for a single billboard. I would agree with that. But I do believe that you can require a property to be subdivided and require X square feet of lot area for Y square feet of sign area, and have a floating minimum lot size.
Aren't these all freestanding signs? All these dots are freestanding signs?
Yeah, some are on the side of the building, like if you look at St. Mary's.
Well, that's permitted now, right?
Well, you could put a 64 square foot sign on Argus Printing across from
No, you can put a
St. Mary's entrance.
You can put a 50,000 square foot sign now, right?
No, I don't.
Yeah.
Jim?
Yeah. Go ahead.
Jim Bradbury, Chair of the Design Review Board. You couldn't be St. Mary's Church and put a 50 square foot sign representing somebody else.
Yeah.
The sign has to represent your building.
Okay.
I mean, your business
Under our
or
ordinance now.
institution. Yep.
Yeah.
So also along School Lane, I have 1, 2, 3, 4, 5 red dots. If you, I mean, not that they would put them on the garage doors of the new townhouses, but that would be great advertising space. It's the new.
Yeah, but where would they
playing field.
park? If you put a freestanding sign there, where would they park?
Well,
You got to take a parking
They
away.
can apply it to the back of the Gap. They could put a sign right on the back of the Gap for Bud Light.
I thought these are freestanding signs we're talking about.
Freestanding off-premises signs.
No,
Or
that's yours. I'm talking about ours.
You can apply, you could, with this new ordinance, you can apply it to a building, right?
No, don't they have to be freestanding? You can apply it to a building?
Yeah, and then you can apply it perpendicular to it, on a building, to the cartway. So that's, at first I didn't think you could do it in downtown Wayne, but then I thought, well, you can meet ADA, so you can get underneath the sign and still have an 8-foot sign, so it will pollute Wayne, in my opinion.
Well, I'm going to invite other members of the public to approach, and then maybe we can go back to some of the thoughts that you've raised.
Okay, thank you for your.
Sure.
Good evening, board members. Kenneth Taylor. I will live, I guess, within about maybe 200, 300 feet of one of the proposed districts.
Okay.
I had some questions that probably could best be responded to by the solicitor. But first, I have to say that I don't agree with the solicitor's conclusion that this is an inoculation against what was the genesis of the Exeter case. I do agree with Mr. Crawford's analysis, however, that that case merely said that 25 square feet is not enough. It didn't go on to say what is enough. So the concept that 64 square feet is going to prevent this township from becoming involved in legal controversies at its expense, that's not within the at least my reading of the Exeter case. The case stated that industry standards, which are the other two measurements that Solicitor Rice mentioned, 672 square feet and 300 square feet, those by themselves were not deemed to be the standards that the individual boards should take up in crafting the ordinances. 25 is too small, 672 and 300, because they're industry standards for normalization or uniformity of the covering of the billboards, are not something that the various township boards must adhere to, but it didn't say how big you need to make it. So the concept that 64 is going to be just right and is going to save us from having to go into court and fight the kind of battles that Exeter fought is not necessarily borne out by the wording of the case.
So do you have a recommendation as to what we should be doing?
My concern was that to ask the solicitor or even the board where that square footage came from and perhaps why the solicitor is confident that it is going to prevent the township from becoming embroiled in legal battles of this nature. And also, I'm a bit concerned, and again, this is perhaps something the solicitor can respond to. I'm a bit concerned about why we have abandoned the direction that Haverford Township is taking in this matter, and that is that they're attempting to preserve the right to challenge these on an application by application basis, based upon factors such as public health and safety, in particular the impact that the signs would have on the safety of vehicular traffic in the neighborhood. And perhaps the solicitor could indicate whether those challenges or those concerns are going to be able to have any merit to them or any potential for challenging the location at these hearings on the special exceptions.
Mr. Rice, can you respond?
I'll try to. I always get nervous when an attorney stands up and starts asking the solicitor this many questions, but
Well, I think it is a fair question.
They're all fair questions.
We've all been going back and forth about the size. So
it's not an easy issue, and I don't think anybody. I particularly don't like proposing something like this that I know most of the people that are living in that neighborhood are going to be against. But, you know, I've got an obligation to advise this board and the community that they're at risk, and I think they are. The 64 square feet basically came from the size of 2 pieces of plywood as a size. I'm also aware of some other ordinances that have been enacted with that size, 64, 50 square feet, in similar types of locations. I think the one thing that the gentleman, is it Mr. Taylor, missed in the Supreme Court case is that that court seemed to tie in the size of the sign to the type of the road, the speed of the traffic on the road to the size of the sign. So we had a lot of discussions, the staff, myself, the township engineer, we drove around and we looked at the speed limits going through the areas and you know, came up with that size, which I think is sufficient at the speed that goes down Lancaster Avenue. It's a fairly consistent speed limit, as I recall. Supreme Court seemed to say that these things have to be economically feasible, you know, up to a point. They rejected, which, in that opinion, the 300 square foot industry standard, the 672 square foot industry standard, and that's something that would be the alternative if we don't have something that's actually feasible. I mean, there's a lot of case law on zoning regulations and municipalities that seem to zone something and permit something, and when you actually try to apply it specifically in your township, you just can't do it for a lot of reasons. The map that we looked at tonight, I'm not sure these all represent actual potential spots unless you apply the height or you apply the setbacks from the cartway, the setbacks from the right-of-way, you know, what's physically there now. You know, there's definitely an opportunity here for people to put up these signs in Wayne, and that's the township's obligation, to provide an opportunity, not to mandate it, not to make sure it happens, but to provide an opportunity. The other question, Mr. Taylor, that you brought up is whether, and I don't know specifically what the other municipalities are doing, and I haven't read their ordinances, but I do understand that if there are total exclusions, they're at risk, and you can fight those applications on a case-by-case basis. But this Supreme Court's pretty clear. When it comes to these uses, they consider them legitimate business uses that every township and borough has to provide somewhere. I think those arguments, though, are proper arguments on the special exception applications that'll come in. That's the scrutiny that I think anybody that's living down there, the township, any resident that has an interest or an application, I think that that's the more appropriate place to put limits on it. I mean, it's certainly possible. Somebody comes in with a 64 square foot off-premises sign down there, and there's 100 people in this room that want it reduced to 50 or 40 or something smaller than that. And that's the type of balancing that the zoning hearing board can certainly consider. The design materials and anything else that's in this ordinance or the existing ordinance. I think that's where you limit the number and the type in front of a zoning hearing board on a special exception application.
Is it your opinion that the positioning of the sign relative to safety concerns, especially having to do with vehicular traffic, and I mention that because it would seem that, at least from the proposed ordinance, that a great number of the signs that would be permissible would probably be installed perpendicular to the road rather than an angle, which on an interstate or on a highway or even that stretch of Tredyffrin that Mr. Crawford was referring to, the signs are placed at an angle so they could be observed, but observed while still pointing your head in the direction that you're supposed to be pointing it to safely drive, rather than to look 90 degrees to the right to read a proposed sign that's a mere 64 square feet. And I think that the
traffic
decision made reference to, it said economics weren't really on the record there, but it made reference to, as a source of the challenge of the 25 square feet, that the kind of content and the size of the lettering that most advertisers would like to place on the sign were really, basically prevented by that small of a sign.
Right.
We're not getting that much bigger, but is it your opinion that at the special exception hearings, the placement of the signs vis-a-vis traffic safety will be able to be an issue that's vetted?
That's always an issue with signs, whether they're a distraction, for either the traveling public or the pedestrian
Whether the
public.
spotlights are going to be shooting
That-
right onto the
all-
highway.
All of that gets scrutinized. It's difficult to sit here with an ordinance and try to predict. I've heard some predictions tonight, but it's difficult to really predict what actually is going to happen in this situation. And, we may find out a year from now that nothing's happened, or we may find out a year from now that we need to tweak this. We've got to provide an obligation. I would hate to see 300 or 600 square foot signs anywhere in Radnor Township. And it's, this is what we came up with in the short window of time that we have. I think I started working on this around March 6th or 7th, after a couple months after the municipal cure. And we spent, the staff spent a fair amount of time driving around and trying to predict, what the regulations would do. So there's a lot of design criteria in here, and I'm not sure all these red dots are actually specific locations. But traffic safety is going to be important on that road. Some municipalities are totally, and we have some prohibitions against revolving signs and lighted signs and blinking signs, which will prevent some of the traffic problems that other townships are dealing with. So, yeah, my long answer is yes. It's an issue.
Lastly, I know the zoning hearing board has its own solicitor, and I don't know the pecking order or the chain of command relative to you and the solicitor for the zoning hearing board. But are you confident that at these special exception hearings that we won't see a repeat of what we've seen occasionally from the zoning hearing board, where the board and the applicant, perhaps trying to avoid litigation in the future, get into somewhat of a let's make a deal scenario about what the applicant is seeking versus what the board is apt to grant?
Well, the zoning hearing board, and I haven't been in front of the zoning hearing board, they're a separate judicial entity, and the planning code requires that they have a separate solicitor, unrelated to the township. And if there is a particularly troublesome or controversial application in many townships, the elected officials say to the township solicitor, we want you to go and oppose this. That happens all the time. Township solicitor then appears, calls witnesses, calls experts, and presents the case. If it's a good case, you should win. If it's a good case and you don't win, then there is appeals that happen. I mean, that's the way a lot of municipalities deal with these types of controversial applications. It happens all the time. So, I mean, that's a decision, a policy decision that the elected officials have to make on a particular application.
And if safety issues come up before the zoning hearing board, would it be the requirement of the individual neighbors who may be concerned or mounting an opposition to a particular special exception, would they be required to retain experts, as I would assume the applicants are going to be on safety issues, to place that on the record before the zoning hearing board? Because the one thing that was very consistent in the Exeter case was that there was the appellate court opined about the lack of a record on anything except the 25 square foot issue.
Always good to make a record in front
Again,
of a zoning hearing board, but
the
neighbors
would have to hire the experts.
Well,
the township wouldn't do it.
the township can take whatever position in a case like that the elected officials decide. They can retain experts. They need to authorize. The residents can do the same. I've been involved in many cases where the experts have, or the residents have a set of experts, and the township is there with a set of experts. That happens in many municipalities. It depends on what the issue is, and what the need for the experts are. But it's, zoning hearing board proceedings are like court proceedings. You can go, they can last 20 minutes or they can last, I hate to scare the Board of Commissioners, but I had a 56 nights of testimony and a curative amendment in a township about 2 years ago. We had 56 nights of testimony. It can last that long with, this would not, that was a fairly huge development, but, that's what can happen when you have a controversial application in front of a zoning hearing board. But there's no obligation that the residents do anything.
John, I have a couple questions. John Rice. There were examples of neighboring townships like Haverford Township, who's now facing an applicant. And one of the questions was, would it make sense to fight these applications on a case-by-case basis versus, being proactive like we're trying to be here? In my mind, it makes sense to do what we're doing here, and we still may have some battles, but I think we may win the war if we do it this way.
My experience is that when you have a total exclusion, that's a tough battle. You're basically going to ask the Pennsylvania Supreme Court to make new law. And you've got a 1965 case from that court before the MPC which says you've got to provide for off-premises signs. That was a total exclusion case. And then you have the more recent one, which is Exeter Township, which is a partial exclusion case, and says the same thing. You can't just have an illusory ordinance which appears as if you permit the use and it can't actually be done for whatever reason. If you want to fight battles over these, I believe, and they're not easy cases, but you go to your zoning hearing board when one comes in that you want to oppose, and you spend your time and your money there and not dealing with landowner curative amendments or substantive challenges on a case-by-case basis. Because the remedy is so severe. They get what they ask for when they file. Unless you can negotiate something less than that, they get what they ask for.
And my second question would be, we've gone with 64 square feet. The existing code allows for 50 square feet. Would it make sense? Would we gain the same protection if we dropped our number to 50 square feet? That would be out of respect for the existing code in the district we're talking about, but would it afford us the same protection as the higher number? Does it put us at risk by going to 50?
That's a difficult, question for me to answer. Probably not, but I'd like to have somebody, a planner or someone else, take a hard look at this down the road. I don't think you can do that tonight. If you want to look at that going forward, you're under a timeline because of the effective date that's in your charter for ordinances. You've got to act tonight. I know there's some suggestions to put this off, and that's may be a good idea to continue to look at this, but you can't change that number at this hearing and not go through the whole process again.
I think you may have just, in that last comment, addressed my question. Item E, is there any magic to that 100 feet? Could you increase it to 150, 200 feet?
Kevin, I think we had maps at 200 feet. I think Matt Bauman we had drawn some maps at 200. We had drawn them at 150. And that area got smaller and smaller to the point where you were excluding a lot of the area. We can relook at that. It's not something that you can change tonight without going through the whole reenactment process again.
But, let me react to your comment then, John. So if you're looking at this map where they put a dot every 100 feet, my theory, very simplistic, was okay, if you take it to 200 feet, you cut them in half. But what you've just suggested is this is probably not a realistic concept. based on?
Unless all of the setbacks have been applied to these dots, and unless these dots represent actual signs, I mean, they may impact traffic safety in some fashion. There's a setback from the side, from the cartway, and there's a setback, I believe, from the right-of-way, from the highway, 10 feet from the street cartway, and no off-premises sign within the right-of-way of any street. I mean, you'd almost need to put on this map to see if it's accurate. And, I mean, it's a rough estimate, I'm sure, but you'd have to draw those right-of-way lines and the 10-foot setback lines, which we haven't done, and then you'd have to look at the buildings. Could you actually physically, you know, put something, or is it all glass, the front of some of these buildings? You know, you would have to do that to determine how accurate the dots are, in my opinion.
All right, I'm going to ask a question, and if your advice is it shouldn't be answered in this setting, I'm okay with that. Did you and Matt, based on your analysis of your driving and the diagrams you did, come up with a estimate of how many potential locations there are?
No.
Well, I guess most of these dots would have to be, they couldn't be freestanding signs. Most of them would have to be painted on a building.
You can't paint. Painted signs are prohibited.
Yeah.
It would be a wall sign.
So can St. Mary's put a sign up for Geico in his front yard? On the corner of Lowell Avenue and the Radnor Middle School?
I mean, I
They have a
can't
dot
tell by
there?
looking at this.
Yeah.
I can't tell that by looking at this map.
Cowan's Flowers,
What's that?
Cowan's Flowers, any side, or take your second story.
They'd have
As
to,
long as it's under 15 feet.
they'd have to put it on the building though. They don't have any room. Yeah.
But they can do that now.
Not an off-premises sign. They can only put their own sign.
Yeah, but there's not, you know, off-premise, there's no place here you can put an off-premise sign except maybe St. Mary's or St. Catherine's or, you know, Wayne Presbyterian. I mean, they're not going to put up signs.
John, let me ask a question on the timing of this. How much time do we have under the MPC after we've announced the curative amendment process before we have to enact an ordinance pursuant to that process? Is it 180 days?
180 days. Correct.
And our clock began January 5th,
Correct.
so technically we have until early July.
Except that you have an effective date in your charter of 31 days. So that's what advances that 31 days.
Okay.
So your last date to actually enact this ordinance would be June 5th.
Now, Fron, I think you started out by saying we have time. Do you agree with John's analysis as far as the timing is concerned? Not to put you on the spot, but
Yeah, the normal effective date, I'm not familiar with the 31 days. Normally, an ordinance can be made effective in 5 days. I'm not sure that the 180 days requires to be effective or to be passed. There's also a question of the pending ordinance doctrine. So I haven't tried to really focus on that timing issue, but you know, under the MPC, certainly you would have additional time. I haven't tried to focus on that. Any glitches? to it.
I'm simply suggesting that we're getting a lot of information on our plate tonight, and it's nobody's fault that we're getting it late in the game. But I just wonder if we have any wiggle room in terms of the time. And you're suggesting we don't, John?
Now, what Mr. Crawford's referring to is the second-class township code has for all ordinances, effective date of 5 days. That's pretty typical. You'll see all the but your charter, very unusual. And when I set out the timeline a couple months ago, I pointed that out, that you have a 31-day effective date before the ordinance is in effect. It's a 31-day under the charter. So counting back with the 31 days, you've got June 5th as your last day to adopt it, and it's not effective for 31 days after that. We advanced that to tonight so that we'd be well within the time period.
And the pending ordinance rule wouldn't assist us in preventing somebody from coming in here in this window, so to speak. If we don't act, and somebody comes in here, they could ask for a curative amendment to put up a large sign.
Pending ordinance might provide some protection, but there's no case law on that yet. I'm in the middle of one of those where we had a municipal cure and the pending ordinance rule was invoked beyond the 180 days. It's something that I wouldn't risk at this point.
I think the pending ordinance rule, I would agree, is not what I would really want to hang a hat on. But I had thought the language of the 180 days was that it had to be passed within 180 days.
Well, I'm looking for my MPC.
Again, I haven't re-reviewed that because I wasn't aware of this issue. But if it says it has to be effective within 180 days in your charter, it says it won't be effective for 31 days, then I think the time limitation puts you in a bind. But if it allows you to have the ordinance passed within 180 days, then I think that's a different issue.
Well, assuming we're stuck with this time bind and have to act tonight, it seemed to be the prudent thing to do to at least put it through, because the likelihood someone's going to come in here and put applications in for signs all the way up and down the pike is probably minimal, so that we'd have a chance to take your suggestions, analyze them, and determine whether or not we want to change the ordinance.
I would agree with you, Hank, on the relative risks of something happening quickly. I think you're right. I would ask you, though, to keep an open mind about trying to tighten this down, because I do think it's an open invitation for a bonus revenue for every property owner in Wayne, every commercial property owner in Wayne.
I respect your opinion because you acted as our interim solicitor for a short while after Gene Evans became ill, so I know you have your heart in the right place.
Yep. I don't have any axe to grind other than we want to preserve the church property and the ambience of Wayne. So.
Can I just entreat the board to, it isn't often that this board has a public hearing and has the necessity of voting on the proposed ordinance on the same night. I think and I realize this is a sort of a one-off situation and there is a bit of imminency involved, but if at all possible, this was a little troubling when this was originally announced that the public hearing would be on the very same night that the board was expected to vote, and I think the potential for enacting an ordinance that is maybe a little further from, while not perfect, it's a little further from perfect than it otherwise would have been if the board would have seen fit to schedule the public hearing on a night other than the night it was voted upon, and just ask the board that if that can be avoided at all costs in the future.
Yeah, the alternative that I see, Ken, and it's a doomsday scenario, I'll agree with you, is that somebody along the Blue Route comes in here and files a curative amendment and says, I want a 600 and some billboard on the Blue Route.
It's a scenic highway. They can't put it on the Blue Route. Can't put it on the Blue Route. It's a scenic highway. That's why we didn't discuss it.
All right, we'll stick it at the top of the spillway in the
Well, Lancaster Pike, right there where that abandoned building is at Radnor Chester Road. Yeah.
Well, my point is, the doomsday scenario, wherever that sign may go, is something that I want to avoid.
I as well. It's just that I don't know how long ago this ordinance, curative ordinance, was drafted. It's just that if the agenda permits it and your workload permits it, I'm just suggesting that if at all possible costs, if the hearing could be on the night perhaps before.
It almost always is. I can't remember another time when it wasn't.
But we have discussed this at numerous meetings over the last 5 months. This isn't just, we just didn't bring this up.
This is when the public get their input, and our ideas
Well, we have public meetings.
might not see the light of day, but this is when we get to bring them to you. And it would be greatly appreciated if we don't have it on the same night in the future.
Jim, okay, thank you. Jim Bradbury? Yep. Jim, when we worked on this over the last 4 or 5 months, the idea was that rather than going all over the township and permitting these everywhere or otherwhere, that if we limit it to these two areas, we really wouldn't get many signs. That there's really no place really here that has that much traffic other than
Right,
Lancaster
well-
Pike School, and, and I just wanted to get your thinking.
Okay. I had, Jim Bradbury again, Chair of the Design Review Board. I had some prepared remarks, but as I'm sitting here, I'm writing down about 500 other things that I want to talk about. And I appreciate, the time, and I know we're trying to get all this done. But can I just ask a couple of things? First of all, Mr. Rice, can you just clarify for me as a non-lawyer, if Exeter Township had an ordinance, why were they not protected? Granted, the ordinance was deemed not constitutional or whatever it is. So what's the difference between them having an ordinance and not having an ordinance? They were still taken to court and sued, correct?
Correct. Correct.
So everybody's sitting here talking about a doomsday scenario and curative filing and all that. Why are we any more protected than Exeter was?
Because we got a better ordinance than they have.
Well, do we really?
On the advice of our solicitor.
Bill, okay, let me just keep going for a second. Okay. Secondly, I would ask the same question the gentleman just said about the 180 days, the risk reward of not doing anything now, but to make sure that you get the right ordinance. And also, are you setting precedents if you pass this tonight and then come back 6 months from now and say we want to pass a more restrictive ordinance or a different ordinance? Is that opening yourself up to a lawsuit because they say, well, you had this ordinance in and then you came back and changed it? You don't have to answer that now, but let me just come back to that.
Answer is no.
Okay. Third thing is, just to your question, Mr. Herveda, you said that it's very unlikely, and Bill, this goes to your question as well, that the way this thing is written, it's almost very, very unlikely that you're going to have any billboards or off-premises signs in downtown Wayne. Then aren't we not writing a law that is too restrictive again, to go back to some of the things that Fron Crawford was talking about? Because if you're writing this thing, we think we're allowing people to come into Wayne and give them the opportunity to put off-premises sign, but the reality is, if you can't do it the way the thing's written, aren't we going to be right back in the same boat and open ourselves up to liability as well? And when you said that it's very unlikely, Mr. Herveda, that somebody's going to, rent their side of their building or something to somebody, I've been on the Design Review Board, I think, almost 7 years now. We used to have cell tower applications come in. Villanova University, first time they ever came in, as I recall. Well, we're going to do this as a one-time deal. We're going to mask this. We're not going to. Well, guess how many cell tower applications we get per month? And Radnor does a terrific job in keeping those, out of the, in a nice way. But if you allow it, I agree with Fron, people will come. And I'm not talking about maybe 3 years from now, 5 years from now, but this township's going to be around for a long time. And if you give them the opportunity, they're going to come and try to do that. Now, I don't think there's anybody in this room who wants to see billboards in Radnor Township unless there's representatives from Bartkowski Investment Group, which is the group that's in Haverford, Springfield, et cetera, which, by the way, their acronym is BIG, if you didn't know. I know you guys are working very hard at this. Mr. Loper, Mr. Baumann are doing a great job working to do the best that we can, and Mr. Rice. But the reality is, if you write this thing so limited, 64 square feet, and I agree we're trying to do the right thing here, if they're willing to go after Haverford and Lower Merion to prevent them from putting a 50-foot high billboard that's 672 square feet, you think they're going to roll over and exceed and capitulate to Radnor, who's given them 64 square feet? I just don't think there's been enough time to figure this whole thing out. And I understand the conditions, and there's been a lot on you all's plate, and we're trying to be proactive about it. But I don't think, personally, and I'm not a lawyer, it's going to protect us. I think there needs to be a lot more work done here to figure out what really needs to be done. And back to the issue of the safety issue and the traffic and everything, when I read some of the accounts in Haverford and so forth, I think Mr. Byrne is their township solicitor, and he was making arguments the other night before the Haverford Zoning Hearing Board, I believe. And he was talking about the health and safety issue of billboards causing traffic accidents. And kids are crossing roads, and they're going to be a hazard to that. And billboards can fall down. I mean, those are more specious arguments than I could ever imagine. I mean, how many times have you seen a billboard fall down in Haverford Township? A billboard that's 50 feet high, frankly, is more safe than ones down at 15 feet, because that's where you're looking when you're driving. Okay, so let me, if you don't mind, I just want to say a couple other things. I'll do the kind of flowery stuff first, and then I'll come back to the more specifics. And the reason I want to do this, I'm sorry to take up your time, is because this really has come on. And I know you guys have discussed it at other meetings, but I don't think there's a lot of people in Radnor who know about this and know really the implications of this. So I just want to talk about it for just a second. We're all trying to do the right thing, and you all are, certainly. But as I put out an email to you all last week, there are many jurisdictions in this country and indeed the world that ban billboards. I talked about San Francisco. Nantucket doesn't allow billboards. Los Angeles, which you could arguably say is the billboard epicenter of the known universe, now bans certain types of billboards. The entire state of Maine, the entire state of Vermont, Alaska, Hawaii, Oregon, and Rhode Island are currently looking at these sorts of things. And I'm not a legal person, and I know there's this whole issue with the Supreme Court, but it can be done, or it has to be done in just an unbelievably limiting way. And go back to what Fron had said earlier about what's been done in downtown Wayne with the Design Review Board, with the sign ordinance. We have spent, and the master plan, which the ink is barely 3 years old, dried, is now just going to be thrown, baby out with the bathwater. It's just unbelievable. And I'm not blaming you all, but I'm just sort of sitting here looking at this as a scenario and thinking about the potential consequences. And I think it's very, very troubling. So just want to take a couple of specific questions, and maybe they're answerable, maybe they're not. And the first of all is can't there still be lawsuits? And what is any ordinance going to protect us from? As I say, if they're willing to go after some of these townships,
There can always be lawsuits.
if you're willing to go out after 672 square feet, you're going to go after 64 square feet, big time. That's my first question. Second question is, why aren't you opening yourself up for lawsuits from other people other than, say, billboard companies? If I live in Garrett Hill and I own a gas station, I'm not making enough money, and I want to put a billboard on my property, can I sue the township for not allowing you to put it, because you're only allowing the Wayne Business Overlay District? Thirdly, we've gone with the sign code, which is terrific, and all those businesses in downtown Wayne, which we absolutely by the book, make stay under the 15 feet. The code says 14-inch high letters. We make them adhere to 12-inch high letters. We use the Mac-McCoy rule that just kind of limits those people. They're now having to go to a higher standard than somebody who could not even be from the township. I mean, it could be Clear Channel from God knows where coming to the township trying to make a buck. And our township people are being penalized because we tell them you can't rear illuminate your sign. So I would say that, I would throw that out as well. And if it's a matter of buying time, and if in my opinion, again, not as a legal person, you need to adopt some ordinance, adopt an ordinance that says we're going to allow one billboard in the township of Radnor. And it's going to be 8 square feet, and it's going to be 10 feet high, and throw it against the wall and see what happens. But it seems to me if you adopt this, we really are looking for some trouble down the road. And then the final thing I'll just say, I think this was sent to you all in an email. This is a rendering, which, I guess you can see up there. Again, this is very abstract, very quickly done. This was Maurice Weintraub, who's a practicing architect in Radnor, who's in Wayne, very concerned about this as well. It doesn't show, where this is not matching real parcels and, cartway setbacks, et cetera. But this is the 15-foot high. This is the 64 square feet. This is the 10-foot from the cartway, and this is the 100 feet. So in the ideal universe, this is what could happen. Granted, it might not happen in Wayne. So thanks, and hopefully we'll see if we can do a better job here.
Well, my original question was, as you look at it, I don't know if you saw this map.
I saw it briefly.
Yeah.
Well, I mean, it is and it isn't, Bill. If you could stay, would like Mr. Herveda said, if I'm Wayne Sporting Goods and somebody wants a 64 square foot sign on my building, and I got to put it on the building because I can't put it in the cartway. Well, obviously you're not going to go over your own sign to do that. But the sides of buildings, whether it's high road cycles or, like I was saying, Cowan's Flowers, many of those sorts of places, and then the larger parcels, the Acme, well, it's not allowed in the Acme parking lot. But further up, the bigger properties, you could certainly do that as well.
Well, I mean, my opinion, and we've been discussing for 5 months, is that this is so restrictive that the chances of, 1 or 2 signs happening.
Then I would go back to, and again, Mr. Rice, you all can speak better to this, then why isn't it too restrictive?
Well, because we're giving them the opportunity, they can do it. But most of these people are not going to choose to do it. The Presbyterian Church and St. Mary's in Radnor Township, you know, we're not going to do it. You know, and then, like you said, all these stores along Lancaster Pike, they're not going to put a 64-foot sign in front of their building, which you can't see anyway if it's, you know, you got to turn sideways to look at it. Billboard company, you know, if you go up to Devon, those are angles so that when you drive down the highway, you see them. When you drive down this highway, you're not going to see those signs up against those buildings. You know, and so as I look at all this, you know, I don't see very many signs being put up here in the future.
I have a question.
And the alternative is to look at other areas of the township and open other areas of the township open for signs. You know, I mean, provide them somewhere else.
Right.
For John Rice. John, this ordinance has already gone before the Radnor Planning Commission and also the Delaware County Planning Commission?
Yes.
And did those commissions have any recommendations to us? Would they normally give us recommendations on an ordinance or not?
Well, your planning commission had some questions, and we had a discussion generally about signs in a lot of different places, including the SEPTA stations. But they recommended approval. The county planning commission had some concerns, expressed some concerns about Wayne business area, and I think some of the concerns that the other folks have spoken about tonight, but they made no separate recommendation in terms of how to address the legal issues, which is what we're trying to do here. These are pretty clear legal issues that we've got to do something about. And I think, I mean, what I've heard tonight, just some good comments, but and going forward, maybe some of those comments can be incorporated. I think the issue of separate lots, again, I'm not sure whether Mr. Crawford is referring having that in Wayne or in other parts of the township, but I think in other parts of the township you could do that. But then you're opening up other parts of the township to probably larger signs. If you have separate lots, you usually have larger signs. I've done ordinances in rural municipalities that have 10,000 square foot lots, but they permit 300 square foot signs. So you still get, you know, if you go that route, you have bigger signs. The way this is drafted now, I mean, I agree with Mr. Spengler that I just think that to some extent the business owners are going to police themselves. If not, there's a zoning hearing board that's going to have to approve something that fits in to Wayne, that is not a safety hazard in any way and meets all the design and setback criteria that are in this ordinance. I think there's some self-policing here that's going to occur, but I'm sure somebody is going to put up a wall sign on some of the walls that are down there at some point.
Or sue the township when the zoning hearing board turns down their application.
Well, the zoning hearing board has to have grounds to turn down an application. They can't turn down any type of an application because they don't like it. There's got to be some zoning basis or some safety basis or some even aesthetic basis to some extent for a zoning hearing board to deny a special exception. There's got to be some facts and some reason under the zoning ordinance for them to make that decision. But that's where I think that's where these arguments are going to be had in front of the zoning hearing board.
When someone comes in and applies for a sign, do they go to the design review board?
That's the first step.
Yeah,
Before the
right.
zoning hearing board, the ordinance requires a recommendation from the design review board.
One last question. John Rice, if we were to pass this ordinance tonight, what is the process if we wanted to, say, a few months down the road, amend this ordinance? Can you just describe the process for the public, what we would be doing to do that?
Well, there would have to be a proposal in terms of if you want to amend one or two sections. We heard maybe some of the setbacks tonight. Some of the other criteria that have been suggested, putting that in some kind of an ordinance form. We would do what we did with this ordinance. It would go through the local planning commission. It would go to the Delaware County Planning Commission. This board has a procedure where you introduce an ordinance at a public meeting. You did that in this case. And then it moves on and goes through the process under the MPC. We advertise for a hearing, and you can adopt it that night or not. I mean, tonight, you really don't have a good option at this point. But it's not unusual to have an ordinance like this be adopted and then be worked on immediately to tweak it because of some of the comments and some good suggestions. That's not an unusual event. That doesn't create any other liability issues, provided that there's a good basis for how we're going to tweak it, and we're not taking something away, that gets us by the constitutional issue that the Supreme Court brought up. But it's the same process, John. Same. You follow the MPC. You have sort of extraordinary requirements in notice and advertising in the Home Rule Charter. So you follow both of those procedures. And
So I'll just recap. We introduce, we pass to the planning commissions.
Correct.
We advertise twice. We have a hearing, and then we can either adopt the same evening or hear more. Okay.
It's about a 60-day process, depending on what you're trying to do. But it's about 60 days to follow the charter and the MPC.
John, based on the language here, is it a risk, an imprudent thing to ask Matt to put together a map like this that says, and I don't even know if it's even that hard, if it's extraordinarily difficult, potential locations for the actual signs based on the language here?
We could certainly do that. I'd want to talk to Matt before he started down that process. I think that there's enough opportunity the way this is, but it wouldn't hurt to, have your planner do that and look at whether or not there's this many red dots or something less than that or something more than that. But that's not something that in the short
Understood.
time frame we had we could do.
But it just might be useful if it's, because it sounds like the direction we're going is to look at fine-tuning this downstream. And it might be helpful information to better understand. Because I look at this, and if I understand the map accurately, one location is the post office, one location is the library, one location is Joe's. So I don't know if Marty's going to give him rights to a sign. Yeah, so, there's I think there's some dots here that probably are not realistic, and it would just be better for me to understand what's a realistic look at this.
But, understand what that involves for who's ever going to do that.
Yeah, I'd like to understand that as well.
Going out and looking at the buildings, too, probably.
Yeah, I don't know exactly. Yeah, I'd appreciate before embarking on that task, what's the effort behind it? It could be a completely naive question, not understanding that it might take months and months of effort to do that.
I don't think that's Joe's. I think it's Capri's, but Marty can tell us better about that.
I don't want to cut you off, but if you don't mind, it looks like there's a couple other people that want to say something, and then Mr. Bradbury, you can come back up.
I will be brief, I promise. I'm Susan Byrne from Luella Court, which is right there. So of all the residential neighborhoods, that's probably one of the ones that is the one that is most impacted by this decision. It's my sense that we don't have a lot of wiggle room negotiation time at this point, but I'd like to suggest that if you need to pass this tonight, pass it tonight, but then let's start immediately working on something that is a little bit stronger. And I have two suggestions. One is that by saying that it's every 100 feet, I think that gives incentive to be the first one in the gate. Because if you don't get your 100 feet, somebody else gets it, then you lose your opportunity for that income. The second one is I'd like a third setback added, or the second setback changed, that the 100 feet is larger than that. Because we're completely surrounded by this. I think if we do change the setbacks for historic districts, then we fairly layer another piece on top of this so that it protects the periphery of the business district as well. Does that make sense?
Yeah, I understand what you're saying. Anybody have any Mr. Rice, do you understand what she's?
Yes. I mean, you're talking about increasing the 100-foot setback to something greater than that.
Yes,
150 feet or 200 feet or something like that.
yes, but also putting the historic district piece into it, because that would allow the churches to go for some type of historic designation and then get coverage that way. Do you understand what I'm saying?
I'm not sure I understand that
Okay,
part.
if you put a third setback in there that says that it's, say, 200 feet from the boundary of a residential or non-residential historic district, which would be North Wayne, South Wayne, and Luella Court, then you're extending the boundary a little bit more. And I think it's very reasonable. I don't think most courts would have difficulty with that. Then if the historic districts expand in town, you're putting in a provision that might assist you, too.
Okay, I've got it.
Okay?
Understand.
Okay, thank you.
Hi, Baron Gemmer. I just have a few comments regarding the language that clarifies or that specifies where the billboards of the off-premises signs can be placed. The first wording that I wanted to have a comment on is the new proposed 280-127A, 1 and 2, where it specifies the WBOD and the C3. The first part, number 1, says the Wayne Business Overlay District, and that's fine because that's a big contiguous district, so there's no question it's part and parcel as one area. The second, where it refers to the C3 zoning district, provided that it has frontage, there are arguably 4 C3 areas within the township.
It also says about a railroad.
Well, but my point being, Bill, is that the 4 portions of the C3, the one at Conestoga and Lancaster, the one at Garrett Hill and Conestoga, and the 2 that are a part of this, make up the C3 district. So the C3 district does have frontage on the railroad, so a lawyer could easily argue that those other 2 areas are in play because they are part of the C3 district. What I would propose...
It's a C3 district that has frontage on a railroad. They don't have frontage on a railroad.
But they're part of the... You're saying that they're a C3 district. They're not. They're part of the C3 district. So I would propose language that would say any contiguous C3 zoning district area. So it would definitely make sure we're only talking about these 2 areas. Because I think the district is the sum of all the classifications areas within the township. And the WBOD, it doesn't make a difference because it's contiguous.
Baron, can I just, so 2 would read C3 zoning district provided that the parcel has frontage?
No, actually, no, you could still just literally just replace the with any and just say any contiguous C3 zoning district area provided it, meaning the area. So the ones that do have frontage and not the ones that the areas that don't have frontage. I understand what you're saying, Bill, but a lawyer could easily argue that.
Well, I mean, you could argue everything. No.
Well, that's why we're trying to the ordinance to protect it. So that's the first comment I have. The second comment is down under D there with the setbacks, and it talks about 100 feet from any adjacent residential zoning districts in both areas. We have some weird zoning within the. I won't bother to put it up, but there are some slivers of commercial that divide, like the WBOD and R5, for example, which are less than 100 feet. So you still may end up being less than 100 feet from a residential area just because it's not adjacent or not touching the other. So I would prefer to see adjacent just totally out of there for when you have weird zoning situations. In both clauses, actually, 1 and 2. I can show you. Want me to show you the example?
Keep going.
Okay. Actually, I'm going to show something. He's out of the way here. This goes to Susan's point 2. Hopefully this can zoom in as much as you can on it. Pardon my coloring. There's 2 things I want to show here. One is that we want to make sure that the boundaries are doesn't go to the ordinance, just goes to demonstrating where the things could be. If you see the pink I have highlighted here, those are actually non-commercial, non-residential boundaries of adjacent districts of the WBOD, meaning that setback is not required there. So the blue line would not have to be pushed back in those cases, and that's a considerable amount, just so we make sure we have the map right when we're looking at these. So the blue line that's outlining that is not as restrictive as it needs to be. It would actually be pushed basically to the end because you've got commercial, this is public, this is C3 there, public land use there, so it's not residential. So that's one point. The second point, which
You
is
got a railroad track there.
that's fine, which means you could have the signs closer to the railroad track. If you look at what this is saying, Bill, this just says that you have to have that 100-foot setback from the property line because of the quote-unquote residential district. Well, that's not a residential district, therefore that could move to the 20 feet if it was the railroad, or all the way to the property line if there was no railroad there. I'm just saying that the blue line is not appropriately drawn on this to show the actual area where off-premises signs could be. And it's there's a large number of areas here where that blue line would not have to be set back the 100 feet, because the WBOD is in no way surrounded entirely by residential.
So that comment is just as to where we're going to measure the language of the ordinance.
Correct. This has nothing to do with this is the representation
So
on the maps.
If an application comes in, the mapping's got to be correct to match up with the language in the ordinance.
That's exactly correct. This has nothing to do with the language itself. That's correct. Another point that I want to show here, which is really more to Susan's point, you see the outline here, you see the blue, and then the outline outside of that, the 100-foot, is the actual WBOD boundaries. The green represents HARB districts. So you can see there's actually there, and there, HARB properties within the WBOD, and furthermore, even HARB properties within the allowable off-premises area, within the blue area. So I think it's very important that we, as Kathy said, or excuse me, as Susan said, add perhaps 128 or 280-127D4 to add an additional offset from HARB districts, and I would propose that probably could be maybe 200, because that wouldn't narrow it, unlike making the residential one 200, which would push everything in. But this is a concern because you have properties within the WBOD that are HARB areas.
Oh, are they commercial properties?
Some of them are, but the HARB covers commercial properties. So you've got these ones, these are along West Wayne here. This is at the corner of Bloomingdale and Lancaster. This is on Runnymede. These are the two properties that border Lancaster right off of Luella Court, and they're all within the WBOD district. And so again, some of them are even within the 100-foot setback from where the residential is. So I think that especially if we're going to protect, I would, Susan had suggestions, I would perhaps suggest that whatever you could do the residential, if 100's all you can do, that's great. Perhaps have a second setback definition, which could be bigger. You could make an argument because of the HARB, and it's not going to push it in because it's only going to affect, small portions. It's not going to affect a lot up here or on the other map. And to that end, let me just show here. This is the C3 portions. I don't know if you can see them. Here's the one, and here's the other. This doesn't have to do with HARB, even though the HARB is shown in green here. What this shows is some of these residentials that abut these. So even though this map shows you could have signs along the railroad here, you really can't, because those residentials, you'd have to do the 100-foot from there per the way the ordinance is written. The same thing down here, so you eliminate that, and also the same thing down in this end, both from this side, because that's R5, and this is R5. So a lot of this may become useless. This pink again here, that's public land use, so therefore this setback of 100 feet would not have to be there. Again, that just goes to making sure the maps appropriately display where you couldn't based upon what the ordinance says. So this doesn't show, this is solely based upon the maps. There's no HARB issue here, unless actually we make it 200, which might wipe out even more because of the HARB being there and perhaps affecting down there where it's green.
Baron, could you provide a copy of this diagram along with all your explanations?
Sure.
To staff and to the commissioners. I think it's useful.
And the solicitor.
And the solicitor. It's very useful modeling, and I appreciate what you've done here. Thank you.
If you promise not to laugh at my coloring, that's
I will
that's
not.
fine.
Okay, thank you. Any other members of the public want to participate at this point?
I'm sorry, my name's Evan Bryan. I got here late, so I apologize. But I know Mr. Spingler was saying that this has been going on. You've been discussing this for the last 4 or 5 months, but this is the first time I've heard about this. Now, not saying that I don't try not to be informed. I don't watch all these meetings and everything, but this is the first time I heard about it. It was at a block party Sunday where there was probably 75 to 100 people on Lansdowne Avenue, and I don't think one person there knew about this until actually Sandy Karate informed my wife about it, which I found out about 20 minutes ago that the meeting was tonight. So I think it'd been advantageous for all of you to, if you're going to do an ordinance tonight, that it is special to do an amendment to this and keep this going forward, because I think you would have, you must see there's only 15 people here tonight. I think if most of the Wayne residents or Radnor residents saw all these red dots like I did tonight, that's why I ran over here, I think you'd have a packed building. I think you should know, seeing 15 people here, if people know about all these signs and all these all these signs and all these billboards are allowed to go up in Wayne, I think you would have a packed house, number one. And I don't think we should get caught up on always worried about what lawyers are going to say. I mean, you know, you could have people walk out of the township building and trip on the sidewalk. The township's going to get sued. That's what our society is today. I think we get so caught up in worried about what this lawyer is going to do, what that lawyer is going to do. I mean, Mr. Bradbury, I think, had a real good point. You have some states that don't even allow billboards, or some cities that don't even allow billboards. We should take a stand and keep Wayne, that it's a wonderful life town, the Jimmy Stewart town that it always has been. That's why we moved here. That's why we stay here. I just don't think we should get caught up worrying about what every lawyer is going to, because we're going to get sued no matter what we do, no matter what. And I think it should somehow get out to the public about these billboards. Like I said, 75 people Sunday at a block party knew nothing about this. And I think we would have a packed house if we could somehow advertise this and get this out of what's going on. Thank you.
Well, we're certainly going to have Mount Bauman look at all these dots, and you'll see there are a lot less than the ones that are drawn here.
Anybody else in the public have anything new they want to add? Mr. Bradbury, did you want to say something else?
Just so I understand, it looks like if you all are compelled to make pass an ordinance tonight, point of order, are you allowed to amend it as it is?
My understanding is you can always amend an ordinance. You just have to follow
Not tonight.
No, I meant not tonight.
Not tonight. No, it would have to be a separate zoning ordinance amendment that would amend the same sections or whatever decisions would be made about what sections, if the setbacks would be increased. We'd have to start the process again. You can't, under the planning code, once you advertise the ordinance, you can't really make any changes to it without starting the whole process all over again. So it's up for enactment tonight. It'll be effective within 31 days. And we can start on a new amendment to the same provision, incorporating, once Matt does, and we look at the red dots and some of the other issues. Once that gets done, we'll have a better idea of how far we can go then in terms of making amendments.
I mean, the other option is we could decide not to go forward with it tonight.
You could do that.
Because what I was going to say is if there is any mechanism to allow you to do it, I think, again, not being a lawyer, it would be better to go ahead and amend this ordinance and say, let's make it 200 feet minimum between each sign. Let's go to the 50 square feet, because none of us know what's going to fly anyway. And it would seemingly be easier to come back and soften the ordinance at a later date than it would be to make it more stringent.
Well, we're rolling the dice that someone is not waiting to develop and comes in the next month with some bigger, all throughout the township, 2 or 3 or 4 different 5 sites. That's the chance we're taking.
Right.
Yeah.
Bob, you have something you want to say?
Yes. A couple points, but I'm going to be very brief. The initial drive for this amendment was to cure a blatant weakness in our zoning ordinance relative to off-premises signs. The Bartkowski organization that has been active in adjoining townships has not yet looked in our direction to take any specific action. The other point, when we drafted the criteria, the basic criteria of this draft amendment, we looked at the scale and the scoping of what is specific and unique to the districts where we allow for these off-premises signs to be located. We felt we didn't do a dot-by-dot measurement map, but we talked very specifically about all the properties in the area and which would be more prone to accept this kind of an offering, who would not, where it would be self-restricting. We built in the special exception criteria review in addition to the design review criteria review to create this redundancy of opportunity for specific analysis of a proposed off-premises sign. This is new territory for the township. So based on that, we built in this protective review process, multiple review process, so that in case something does come up, for instance, the historic district, the adjacency to the historic district, and or in the historic district, that in itself will be material enough to show up at the zoning hearing board meeting, and testimony will be presented showing that there's unique circumstances for this specific property because it's located in the historic district. It becomes a justifiable limitation to allowing the off-premises signage. We're not, in defense of Froney Crawford, and I respect Froney Crawford's opinion highly as an attorney and a planner, we're not opening the door of opportunity here so wide that we're going to be bombarded with requests for off-premises signage. That being said, we'll have the opportunity, if the board chooses to pass the draft ordinance as it is written tonight, we have the opportunity to come back in and scrutinize it further in a short period of time as we choose to do that. I would offer my department and my staff, if we want to organize a public commentary for people who have interest in amending the draft that's proposed tonight, if they have specific criteria that they want to brainstorm and come up with better specific requirements, more restrictive separation requirements, we could work with that in an ad hoc sort of situation to anticipate, if we want to go that direction in the future, to amend the ordinance that's in front of the board this evening. So based on that, I think we came up with a draft here that not only cures a legal defect, and yes, we're all surrounded by legal opinions and legal phobias, but this is a curative process that'll take care of a general legal challenge where we would be completely vulnerable, and then we'd have to throw countless dollars of resources in defense of something that we want to prohibit. But it's not necessarily the thinking of prohibition that should be predominant. It's the issuance of allowing it, but manipulating the allowance conditions and locations and restrictions so that it still is regulated and is still going through enough oversight in the township staff and the township boards that we could prohibit those signs that we do not want, allow those signs that we feel are non-impacting to the overall character of what we've been working on in downtown Wayne since 1992. That's all I really had to offer.
I appreciate your comments and your perspective and your offer. Actually, I was writing down the names of the folks who were here and was going to suggest that we form either an official or unofficial sign subcommittee to work on trying to tighten this up along the lines of some of the comments we've heard tonight. And I am assuming, well, I'll ask, is it the consensus of the board to go ahead and pass this tonight based on the work that's been put in it and the recommendation of the solicitor?
From my perspective, it is with the instruction that we move immediately to review the comments and as quickly as possible move to amend the ordinance to make sure that we tighten it up so that the impact is even less severe.
Well, I think the first thing we have to do is we have to get Mount Bauman to look at this area and tell us exactly where these signs can go. And there's probably 70% of them are going to be eliminated because it's not a reasonable place to put a sign. And then we look where the other ones, where they can go, so we know exactly what we're dealing with, and it might not be as bad as, I mean, if I was at Memorial Day and said, look at all these signs that go put in Radnor, I would be very upset, you know? Look at all these red dots. Is there a place they're going to put a sign in Radnor? Yeah, get upset about that. But the fact is that we've done this in a very restrictive way, and this isn't reality. This is just somebody's idea of where you can do it. I'm ashamed Matt's not here but I think he can do the job to show us all as a starting point that, you know, this isn't as bad as everybody thinks it is right now.
I think Kathy wanted to make a comment. Kathy Harris.
I'm Kathy Harris. I live in Luella Court. Aside from the fact that this is in my backyard, I wanted to comment on the public hearing being tonight. I felt like it was a done deal and it was useless to have this hearing until just now when you said that you might amend it. But I feel like if you pass it, you lose faith by the public in their voice in what goes on. I was at the meeting where you introduced it and I objected to it. I still object to it. I feel like our neighborhood's being sacrificed for the sake of other areas. Like, why can't it be in a PB zone? There's only one PB zone, and it's pretty restrictive instead of in C3. C3 is a narrow strip of land bordered by Pennsylvania Avenue, which is residential, and Luella Court, and Wayne Presbyterian. I know I can see the railroad track, the roof of the municipal building, and my neighbor can see the graffiti on the buildings across the railroad track from her bedroom windows. And I don't think anybody wants to see a sign from their bedroom, billboard from their bedroom windows. Billboards belong on highways. I don't understand why it can't be on the Blue Route.
I think we went down that path a couple meetings ago, and I believe the answer is we were told it's not possible to do it on the Blue Route.
Plus, we would want to do it anyway, even if it was possible.
Blue
We're trying to
Route's-
restrict the signs. We don't want, the Blue Route would be the gigantic signs.
Yeah.
So the Blue Route's a scenic highway, we can't do it, so that's done with. But even if it was a scenic highway, I wouldn't be in favor of it, so.
Well, it's a scenic highway?
Blue Route was designated as a scenic highway in 1993.
So it can have no billboards, so.
And the Federal Outdoor Advertising Act controls signage, and you can't put billboards out there under that act.
And if I thought there were going to be 10 or 15 signs in the middle of Wayne, I wouldn't vote for this. I don't think it's happening. But
Well,
I think
I'm concerned about the signs on the Amtrak.
there's not going to be signs on the Amtrak property. It's across the street, down the hill.
Across the street, down the hill.
Can you see Ace Hardware from your window?
No.
No,
but
well, that's where it's going to be. And the thing is, it's not going to pay to put a sign there because nobody goes, there's no traffic there.
It's 100 feet from residential, so what's 100 feet from the railroad track? How wide is the railroad track?
Well, you know, you live right up back against it, you
I
know.
can't
This,
judge.
you can, Luella Court can't see any of this C3 down there.
Sure.
Well, if you can see Ace Hardware, then you can see it, you know. You can see the Burkhead property, and you can see it.
We can.
Yeah.
Some properties can.
Yeah.
Kathy, I think the board is interested in the community being involved in the process. We are up against a tight constraint here. If we don't act, in my opinion, and based on what I've been told, if we don't act tonight, we could end up with a 672 square foot billboard in downtown Wayne, 100 feet above the buildings. I don't want to see that happen.
Okay.
That's really what we're up against. Havertown's facing it right now. And, you know, quite frankly, they're probably going to lose. They're going to lose.
Well,
So I don't want to be in that, I don't want to be the commissioner that voted against this and be blamed for that billboard above Joe's place in Wayne.
they'll probably be on.
Because
Bank
Marty
of
will hate
America.
me.
They'll probably be on the condo above Bank of America.
But I support, I mean, we've heard from several people here tonight. I have their names also, and I expect them to be part of this. I would like to see, I'll support this tonight, but I want to make sure that we get it on the agenda to actually get it through again and make those changes. It's not lip service. We want to make it right. We want to do the right thing. But if we do nothing, I don't think we're doing the right thing. I think
Okay.
we're going to harm ourselves. That's just my thought.
Okay.
No.
And I honestly believe that we have a good ordinance here, and I think when Matt looks at this and we analyze this, we're going to see that we're not that far off. You know, it's not, this isn't a disaster.
If business can find, if the people that want the billboards can find the loophole, they will. And we have to find it first.
You know, well, we're limiting the size and the number. It's not going to be a massive thing that if we don't do something, we're dealing with 13 square miles. We're not dealing with just this.
Well,
See, we don't pass something, we're dealing with 13, I mean, we're dealing with the,
See,
you know.
Kathy, that's the biggest problem. The biggest loophole we have is the fact that we don't allow for off-premises signs.
Okay.
And they'll drive a truck through that one, believe me.
okay.
So.
All right, thank you.
Thank you. At this point, is it the consensus of the board that we move forward with this ordinance as proposed?
I'll move the approval.
All those in favor?
Aye.
Any opposed? Okay. What I would like to do,
Just to be clear, the direction is approved as is, but take the steps to review it.
yeah, that's what I was about to say. What I would like to do is invite the folks who are here tonight who are interested in this, and the names that I have in no particular order are Mr. Crawford, Mrs. Karate, Mr. Bradbury, Mr. Taylor, Ms. Byrne, Mr. Gemmer, Mr. Bryan, and Ms. Harris, to be members of a citizens subcommittee of the board with regard to this sign amendment, the sign ordinance and a proposed amendment. And I would like this group, if they're willing to get together with the Community Development Department and the solicitor within the next 30 days and report back to us your recommendations with regard to an amendment to this ordinance that hopefully is responsive to the points that you've raised here tonight and the concerns that you have. And hopefully we can work that into a better ordinance. If you're willing to do that, we'd love to have your input. Okay.
Well, I'd like to just briefly thank everybody for coming out, because there was really a lot of misinformation. The commissioners want to turn Wayne into Admiral Wilson Boulevard and all this, and everybody was extremely civil here tonight and had some very good points, and I think I've learned a lot about it. I think we have some very good legal minds up here. I'm personally not one of them, but I listened to them, and I think that you guys brought some really good points, and we're very civil about it and understand the situation that we're in. It's a real situation, and we can do nothing and have billboards show up, or we can do something and control it some way and try and do it the way we want to do it. And I wanted to thank everybody for coming in and being very civil about it and having a proactive discussion. It was very refreshing to me.
And just to make it more official, Mr. Crawford, if you don't mind, I'd like to appoint you the chairman of the subcommittee, and that way there'll be a point person.
I'd be happy to help out and count as the attendant of the meeting and have a good discussion.
Thank you.
We may be setting a precedent which will chill public comment in the future.
Yeah.
Yep.
I mean, obviously, I'm being facetious, and I do appreciate everybody's willingness to serve on this committee.
But, I mean, to be fair, the first thing we have to do is have Matt look at this ordinance and come up with the real effect that it has.
And I'd like John, I think he's already started to, consider Frone's recommendations here legally. I don't know if what the ramifications are. You guys are lawyers, but I think knowing Frone, they're probably pretty good suggestions. We can maybe incorporate some or all of, and we have zoning advice here, and Mr. Taylor's legal advice. I think his points were well taken, and I think we can have a better ordinance and do what we all want to do, which is protect Wayne as best we can.
Thank you very much. At this point, would the board like to take a 5-minute break, or do you want to keep going?
We got
All right.
finance and audit left.
We're just about
Okay.
done.
Yeah, let's go.
Then let's go to finance and audit. We've got the schedule of bills payable.
The first item on the agenda is bill list number 09-5B, requesting authorization for disbursement of $2,124,906.31. And these bills have been approved by the respective department head, verified and processed by the Finance Department, and are within the 2009 budgetary limits as imposed by the Board of Commissioners at its December 15th, 2008 meeting. So I'd like to make the motion to introduce this and
Okay.
authorize Amy to pay them.
Is there a second?
Second.
Any questions or comments? All those in favor? Aye.
Second item on the agenda is the monthly budget update. And Amy, you want to kind of walk us through the document prepared, and then I have some questions.
Sure. The document we prepared will be on the website as of tomorrow morning for the public. Sorry about that. The document we prepared will be on the website tomorrow morning for the public to read as well, but this is, I believe, the second month that we've been using this format, where we show where we feel the current year is going to end, given the current trends and facts that we know right now. Before we get into the general fund, I just wanted to touch on the sewer fund. The sewer fund, we are experiencing slower than normal collections. The bills went out at the beginning of April. They were due April 30th. It's not a marked slowdown, but it is something we're noticing. So I just wanted to remind the public that we do have a fairly aggressive delinquent collection program that we will continue. We do add a 10% penalty on once it becomes past due, and then there's interest thereafter. So we are willing to work with anyone who needs it, but please, you need to contact us. Of the delinquent program that we rolled out in early 2008, there were 105 account owners that we had not heard from in several years in many cases, and that outstanding balance totaled $268,000. To date, we've recovered over $147,000, but that still leaves quite a chunk still outstanding. There's currently 18 property owners that have not responded at all to the multiple letters that we've sent, nor did they respond to a representative from the county sheriff's office did serve writs at their property. We are going to be sending them one final letter asking them to please contact us. We have worked out several payment plans with several property owners for nominal monthly repayment terms, anything just to acknowledge the responsibility. But we are going to pursue it the next step, which is filing of judgments. So at the end of the 30 days, we will be filing those judgments. On to the general fund. We had always said that we were waiting on the business privilege returns to come in before we were really going to make an assessment as to where we thought 2009 was going to go. I know we're talking about April 2009 with this report, but since we do know how the returns came in, they were due May 15th, we're going to use that information for this discussion. The business privilege returns did come in what I consider okay, maybe slightly better, but nowhere near levels that would pull us out of the hole that realty transfer and the lack of construction activity and license and permits have put us in. But they did come in slightly better than we thought. However, for the intents and purposes of this report, these are based on our projections as of the end of April. License and permits, if you look at them and where we had thought we would be at this point this year in our budget, we're about 70% off pace of where we anticipated we would be. And that is just a combination of property owners, institutional, residential, commercial, in my opinion, just probably sitting on the sidelines waiting for this to play out. I know there's not a lot of money to be borrowed if people are looking to borrow money, both commercial and institutional organizations. And like I said, I think they're just waiting out this economy to see where it goes. The other part of our revenues that is suffering is the realty transfer tax, which we have discussed each month this year. Excuse me. Through the 4 months of the year, it's down 45%. We have already received our May remittance, which was for sales in the month of April, where one would have expected it to start to pick up a little bit with the better weather and things like that. But actually, that was down 61% from what we received last year at the same time. And actually, that remittance was, in dollar-wise, only $97,000, which is extremely small, and the smallest level that we've received in the month of May dating back to 2000. So with those three revenue line items suffering the way they are, revenues we can see being down as much as $4 million if things don't change for the remainder of 2009. On the expenditure side...
Amy, can I just ask a clarifying question on that? 4 million versus the budget, or 4 million versus 2008?
4 million versus the budget. Now, on the expenditure side, this area is within budget. We anticipate it ending within budget, probably even a little below budget. We had budgeted $22.7 million, and we're looking to end probably about $22.6. Especially considering some of the extenuating expenditures that we've had this year, the staff really is trying to keep this down, but that in no way hides the fact that the revenues are down as low as they are. Fortunately for us, we did end 2008 with an extremely healthy fund balance, and that's the reason that we passed a fund balance policy. That's the reason that we beefed it up for days like this, and we were lucky to have the balances that we do. Our fund balance policy is in excess of $6 million at the end of 2008, which was about 30% of our revenues, which unfortunately we see around the country, and even closer what happens when you don't have a fund balance policy and you haven't planned for the future or weren't able to plan for the future. So while we do have that, and that can get us through 2009, you know, if you start with 6 and you use 4, you're down 4, you're only left with 2, and if things don't change in 2010, you can plow through that remaining 2 very quickly. So we want to make sure that we don't utilize all of that fund balance that's still outstanding. So right now, if we do nothing, if we continue providing the same services that we are with the same staff levels, and there's absolutely no increase in revenues, or the economy does not pick up, that is what we're looking for, probably a current year operating deficit of approximately $4 million. Now, that doesn't mean that it's $4 million overall. We will still have some reserves left over at the end of 2009, but that is what we're looking at. Is that alarming? Yes. This is an area of concern? Yes. But this is the reason that we are doing it each month, and in the month of May, that we can take steps if the board deems it necessary to mitigate this and to reasonably and responsibly cut this deficit as much as we can, and especially put plans in place to help 2010, assuming that the economy does not improve, which we don't know if it will or it won't. You can listen to 10 different experts, and they're all going to tell you 10 different things about whether things are going to pick up next week and next month or next year. So I think we have taken the approach in putting together these projections using sort of a worst-case scenario assumption. This is what we think could be the worst case using reasonable assumptions. Other than that, like I said, we did it this way. We've been looking at it each month, so we can acknowledge what's going on early. That was the intent of the board. The staff and the management will continue to look at services, look at personnel, look at everything we can, and going forward, try and mitigate that deficit as much as possible.
I want to just make sure I understand a few things. The report you put together shows a revenue deficit of $2.9 million relative to the budget.
I'm sorry, I just didn't catch the beginning of your statement.
I want to make sure I'm understanding everything. So the report you put together says we have a revenue deficit of $2.9 million relative to the budget. And you're saying that could be as high as $4 million.
By the end of the year, yes.
In addition, we went into this year with expenditures budgeted to exceed revenues in the general fund by 1.3 million, which means, if my math is right, somewhere in the neighborhood about 5.5 million of the general fund balance could be.
No, and I might have misspoken when you answered it early if I didn't understand it properly. We had originally budgeted to use $1.3 million of fund balance with the 2009 budget. What we're forecasting right now is to use 4.1, so it's not the sum of both.
Okay. Then I have a few questions, and I think perhaps the easiest way to go through this is just flip the pages as we're going through. So I'm looking at the page entitled Operating Budget Fund 1, General Fund, and it says Revenues. And I'm specifically looking at the Grants and Gifts line. Are we confident that our forecast is accurate? The simple reason is we've only got 90,000 year-to-date, and I know some of the money comes from the state and things like that, and the state's budget position isn't ideal either.
Right, and that's why you'll notice that we revised the estimate on the state pension aid. That doesn't come in until the end of September, so we're not even anticipating seeing that until then. We had originally, when we budgeted for 2009, used some sort of a regression analysis. They had been pretty good about increasing it each year. As you can see, we have backed away now, and our estimated 2009 actual from the state for pension aid has been brought back to our 2008 levels.
Right, but my math is relatively simple. April year-to-date, 4 months, 90,000. 2009 estimated actual 1.1 million. Taking 90,000, multiply it by 4, you get 360,000 now. A chunk of that is supposed to come from the state. Again, I want to have a sense of how confident we are at this point in time that 1.1068627 is realistically achievable.
I think it's all realistic with the exception of the crossing guard contribution from the school district. I don't think that's in their cards this budget year.
All right, and you've already taken that out.
Yes. Okay. Everything else is really a timing issue. They come in at specific times during the year.
Okay. I'm now looking at a report entitled Radnor Township Making a Great Place Better. It's a fiscal year 2009 operating budget. It says the upper right corner, prepared 5/20/2009, and it is page 1.
Okay.
Again, my simple math on the mercantile tax. Is there some seasonality to how we collect those revenues? Why would we expect something that's at about $100,000 April year-to-date to yield?
I can answer this general question. If you have more specific for business privilege and mercantile, Bill Martin would be happy to answer that. But the mercantile returns aren't due until August.
Okay, so it's a seasonal
Yes.
issue. How about the amusement tax? It's the same.
The amusement tax, we see more of that in the summer months and the fall, the better weathered months. So that should be coming in shortly.
Okay. Is the business privilege audits monies we recoup via the audit process?
Yes, that's true. Okay. We do know why the business privilege audits is estimated. One might say higher than what we have in so far. There's a couple that are already in the pipeline that we've received.
How about the building permits? We have approximately 125,000 year-to-date through April and 800,000 for the full year. And I would think if construction was going to start in the warmer months, the permits would have been on file by now.
And I can make a general statement, and Mr. Loper, please feel free to jump in. That's another number that we've revised now going into the year. We revised it last month. We revised it again after seeing what came in during the month of April. And at least it's my perspective, and Bob might have more insight, I just think most of your builders, most of your residents who are thinking of building, most of your educational institutions who are thinking of building, they're deferring all of their large projects and pushing it off to the side. So it's a number we have to watch, and if we have to reduce it more, we may have to reduce it more.
Next page. Interest earnings. Why is it so high for the full year given where we stand April year-to-date when interest rates are so low?
According to our cash manager, we have some long-term investments that'll be maturing later in the year that were like 5 years out prior to, so they were still getting good interest rates.
Okay, so you don't, Are you accruing the interest on a monthly basis, or
No.
you'll book it when you get the cash?
Book it when we get the cash.
Got it. How about this other one that represents a potential $500,000 issue, the recreation fee of $536,000? How confident are we that we're going to get that kind of money?
Again, I can make a general statement. Mr. Blumstrom can feel free to add in any particulars, but Tom and his staff are moving into what is their busy time as far as registrations and things like that with day camp. So now is one of their premier times where they're going to see their revenues come in.
So the bulk of that money comes in the summer recreation programs?
I think a large part, and I think we just need to reserve judgment until we see what comes in on that.
Is that a fair assessment, Tom?
That's accurate. If May's been very strong.
Are you confident you're going to hit that $536,000?
At this point, we'll see how the summer goes. What we've noticed is just that some parents are signing up where in the past they may come in and sign up for 3 programs, 4 programs. They're cutting out a program here and there. So we're getting a little minimal.
I'm going to react,
trickle down.
not to you directly, Tom, but to you're just the comment that triggered it. We have a significant shortfall in revenue, and we keep sitting back going, we're going to wait and see, we're going to wait and see. And we said we were going to do this early. We're in June. That's not early. And I'm not convinced that we have our hands around this revenue problem well. So, I mean, maybe it's the nature of my personality, but I just don't know that there's an appropriate sense of urgency here to address some of these things, and I just think we need to deal with that.
I feel pretty comfortable that we're somewhere around 95% confidence level in the numbers. They're only going to go down. They're not going to go up. I think we're working on now is an understanding of the mercantile tax collections, not only for this year, but what impact the decisions people are making today will have on next year's budget. Very shortly, you'll get a program on the other side of the ledger to address that issue. And then I think it's up to the board to make the decisions they need to make.
Okay. That was the end of my questions. Thank you.
I have some questions. Or I want to recap the numbers because I think I feel the same way Kevin does, that we had to wait to see where the revenues would be because of the timing of the revenues as they're received. But we're only getting worse information. The information's not getting any better, and I'm a little worried about some of these projections. Even the Parks and Rec. Tom Blumstrom, just please help me feel confident about this. But shouldn't the summer camps be booked already?
We started taking first days of registration May 4th. That's not on here. We took in over $100,000 on May 4th.
Oh. Yeah, because that's I think it's only showing $30,000 in revenue on the
Yes,
report.
just please remember this is through April 30th.
Okay, that's important. All right, that's good news. That's good news. That helps me feel better. I guess my concern is that with a $4 million projected deficit in spending, we have a lot to make up, and with only we have a timeline in front of us where we don't really start addressing the operational expenses until September, which leaves us about 3 months to try to recover from this situation. If this were my business, I'd be making a decision tonight, and it's not my business. It's the township's business, and I know staff is working hard at this, but we have to get really creative to save $4 million. What percentage is $4 million of our revenue budget?
Sorry about that. It's a huge percentage.
Is it 25%, 20%?
It's close
20%.
to it. I mean, there's no denying that is a large chunk that we need to recoup.
And another way I look at that, what percentage is $4 million of taxpayer revenue? So,
Do you mean if that had to be fully funded by
Yeah.
a tax increase? You're talking double digits to the high
Well,
degree.
our tax revenue from real estate property is about
Nine million in between debt service and the
So
general
4
fund, yeah.
million of 9, it's 50%,
Mhm.
a 50% tax increase. It's absurd. I mean, we can't do that. So we have to cut spending. We have to cut spending everywhere. We have to unscrew half the bulbs in the room. I mean, if this were my house, that's what I would be doing right now. I wouldn't be turning the air conditioning on at my house. And please let me just say this. I think everyone's trying to do the best they can, but, we're all in this pot of water that's boiling, and in September, we're going to die. And I don't want to die. I want us to do whatever we can as fast as we can to preempt this. And I listen to financial reports. I've said this before. I watch financial reporting about 4 hours a day in my office at work. And I listen to experts, probably 20 a week, and none of them are saying it's going to get better next year. They're saying unemployment will be 12% next year. And what worries me is that we passed our last budget with a $1.4 million shortfall. We basically agreed to dip into our fund balance by $1.4 million, and now that is growing or could grow to $4 million, which will leave us with only about $1 million something for next year.
It's more than that. It would leave us with a fund balance of about 14%, or I think it's approaching $3 million.
But if we repeat next year, we will run out of
In
money.
2010, yes.
So we can't repeat next year.
Yes.
I'm just saying it. I know you're working on it. I've seen the report. I appreciate everyone that's working on this. John Granger's working on this. But I just think that I'm looking at the timeline, and I'm thinking it's kind of in reverse order. And again, I just want to make sure before I blurt anything out. This is the report that's going to be on the website tomorrow?
That's correct.
Okay. And this is difficult. I don't like to do this kind of stuff because I see that everyone's working hard, but we have June 15th, 2009, proactively facing unfunded leave time and OPEB liabilities. I don't even want to bring that subject up because that is something so big that we can't even think about that, right? We're talking about millions of dollars there. Okay, but July 20th, exploring options for alternative trash and recycling collection, addressing fees and services on August 17th, staffing September 14th, September 28th, presentation of preliminary 2010 budget. So we kind of magically get through this stuff, and then we're facing the next budget cycle in September, on September 28th, 2009. And I think it's going to be hard enough to make these decisions, but I just don't see how we're going to make up that much money with only 3 months of spending left. I don't know how that works. I mean, wouldn't the cuts have to be substantial if we wait till the last quarter? Anyone?
I don't think anyone's asking you to wait till the last quarter.
Well, no, but I'm seeing.
I think
Well,
Mr.
John,
Granger would
John,
like
be
to
fair. We're going to
address
have a
us.
meeting after this to discuss this stuff. Let's
Well,
be
no,
fair,
I'm
you
being
know?
fair. I'm being fair. I
you're not
think
being
it's
fair.
important to talk about it in a public way,
Yeah.
because
We know
if
we got a
everyone
problem.
understands what the problem is, then we can all work together on it.
Sure.
But I'm
I'd
just
like to-
worried. I'm just worried. Yes.
Mr.
Go ahead.
Granger's been sitting there leaning forward, obviously wanting to address your questions. John?
You're not going to hit the $4 million mark even if you started today. It's not going to happen this year. You got to get this year out of your mind. You're focusing on 2010, 11, and 12. The revenue stream that you end this year is the revenue stream you're going to have for each one of the next 3 years. Not going to get any better, probably get worse, but not a lot more worse. The schedule we laid out last month is an incremental decision-making process. You need to look at the things you are doing and ask yourself in the public, is this what you want to do? If it is, then this is the cost, and that's the number that goes into the budget for next year. By Labor Day-ish, you'll have a budget that you can work with, that'll be vetted in the public. You're not going to be surprised on Labor Day and say, here's the budget, what do we do? You'll be working on it every meeting going forward starting next month. Within an hour, you'll get a game plan that's got 5 or 6 options into it, and they're pretty drastic. But they're the things that you need to look at in terms of what it is you are doing and how you're doing it, because you can't do what you're doing today tomorrow unless you're willing to have a significant tax increase. So there are options, there's opportunities, there's some increases in revenue streams I think you can look at. There are things that just going to have to be vetted publicly, and they're going to take a little bit of time. This is not a thing you wait until Labor Day. You're going to start next month, and you're going to start budget discussions next month. And to be honest with you, that's pretty much what you're going to do for the next 4 months, is talk about the budget for the next 3 years.
Thanks, John.
Anything else, Kevin?
There's one last item on finance and audit, which is the authorization of the annual contribution to the Garrett Hill Parade for the 4th of July, and the request this year is a $4,000 contribution, so I'd like to move.
Second?
All those in favor?
Aye.
Aye. Okay.
And let me just say, the $4,000 invested in Memorial Day Parade was great. It was, you know, you get like 5,000 people out there. It's a great thing for the community to get together on Memorial Day, honor our fallen veterans and those who have served this country, and it was a great day for the people of Wayne and Radnor Township.
Okay. Moving on to the agenda, we are now at old business. Any old business? Hearing none. Any new business?
I have some here somewhere. If anyone else has any, they can go first.
You can save it to the next meeting.
Yeah, I think I'll postpone. Thank you.
Okay. Any public participation? Do I hear?
Move we adjourn. Second.
Okay.